Kindly to mention.
Let us take from that side. Yes. Yeah.
Application for substitution.
Please.
Application.
Yes.
My lord, may I be permitted to mention one matter, my lord? FA 106 of 2018, my lord had passed an order, my lord, giving 15 days to prepare informal paper book and supply.
What an extension.
Yes, Your Lordship, I've been appointed by the High Court Legal Services
No
Committee.
problem. It will appear as to be mentioned there. Just write to be mentioned at the top.
My lord.
Yes.
May I permit to mention one matter? Equity 433 of 2009.
Application or hearing?
Find out,
Application, yes.
My lord,
Yes.
my lord, Honorable Appeals Court passed an order on 22nd August 2023. My lord, there are 9 appeals filed by the Steel Authority India Limited against us. My lord, that order remanded back by the Honorable Supreme Court because they have papered the SSLB on the respondents. My lord, thereafter the Steel Authority by India Limited filed the paperwork after long delay. My lord, kindly see the order.
Now, what do we want now? Tell us that.
Inclusion of the paper.
Appeals.
Yes.
Appeals we are not taking up right now because by our regular bench will come back on 17th. We'll have only 3 days.
My
4
lord,
days.
leave the matter kindly.
Mention in January will definitely take. Yes.
My lord, one is
We mention for what?
My lord, petitioner did not get any maintenance, my lord.
Any?
Maintenance, my lord.
You haven't filed a maintenance application?
This has been disposed of.
Then you have to file an execution
Order
application.
has been passed, my lord.
You have to file an execution case then, or implementation order. To be mentioned won't help you.
Application for inclusion.
Please.
Order 41 for inclusion.
Yes,
my lord, order 14 rule 11.
absolutely.
My lord, admission.
Application.
I'm getting.
Please, please.
item number 1.
Item number 1, I have to put the applicant.
Yes. Appellant is the petitioner.
But this matter was
Expeditious hearing.
no, but I'm telling you, Lordship, this matter was dismissed for default on 10th of January 2018. Thereafter, we have filed the restoration application on
Yes.
2nd of February 2018.
Right.
13 days delay. Section 5 application is there.
No, but you have to serve a copy then.
That we have already served.
Where is the affidavit? File. There must be 2 applications then. You have filed separate applications. One.
One for restoration, which is not in the list. One for section 5.
Restoration, unless the restoration appears, what is the use of what is the number of the restoration application?
But number, if the change brief will not can 1 of 2018. Probably.
What was the previous number?
Previous number will not written here.
You filed it for which code?
What?
You filed it in the computer sheet for which code? Code number 4.
It is not written in my it's a case brief.
You filed it along with 2 condemnation application.
Condemnation application subsequently we have filed in 2024.
Yes.
And the restoration application we have filed in.
But if you don't get the restoration application, what's the use in allowing the section 5? You have to find out where the restoration application has been filed and give that number. We'll direct that to appear along with this section 5. We'll appear both. We will direct both together. We'll allow both together. Without the restoration, section 5 for what? Suppose we allow the section 5, then what happens? Restoration application you have to trace out and affidavits of service filed today be kept on record. Although the application for condonation of delay in filing a restoration application is before us, comma, the restoration application itself is not in the list, comma, nor in the file. The learned advocate for the appellant is appellant shall furnish the particulars of the restoration application for the same to be listed next week. The matter shall next be listed on December 17, 2024. Please trace out during the course of the day. Ask your clerk to do it. Give the number. Mention that with that number mentioned tomorrow, we'll include it.
Great.
Thanks.
Item number 2, I beg to appear on behalf of the degree holder respondent. I'm not the
Respondent.
My lord, I have a preliminary objection before my lord take up this matter. My lord, this has been filed against a dead person. The person who has died on 2006. Now he is asking for substitution of his name after filing it on 2019 in the name of a dead person of the appellant.
The decree was passed in the name of a dead
No,
person.
the decree was passed there with substitution of that dead person in the name of Dilip Kumar Den and Jonaki.
So they are parties in the
The Dilip Kumar, but Aroti they passed away before the decree was passed, and he have
no, the heirs of the deceased are already on record in the trial court.
The heirs of the deceased was already on record under trial court.
If they are a party in the trial court,
But they have filed this appeal in 2019 of by making Arati De that one of the plaintiff in the suit on 2019 when she passed away in 2006. The
will
appeal is
convert this
itself
substitution
available.
application, will treat this as an
My lord,
application.
already this is going on for long, my lord. 2019, my execution is
No,
pending.
if
Bailiff
the
went
heirs
there.
are already on record in the trial court, then
But the heirs
reference of
means
the appeal in the
Dilip
name
Dey is not on record. But trial court, Dilip Dey and Jonaki,
now by substitution, they're trying to bring on record the heirs who are already on record in the trial court. We'll treat this application as an addition of party application and
may I just kindly correct this? My lord,
they're already on record in the trial court. If
But-
this was for the first time, we could have understood.
it's the first, my lord, but they should have made this appeal in a proper form. My lord.
Could have not.
But
For that technicality, we
that
won't close.
bailiff has went there and they have registered, and this decree is of 2019, my lord.
Even then.
Thereafter, it is going on for long, and he's a senior citizen, 85 years
Understood,
old.
but this application
Injunction is only with regard to entry to that premises of 14(1) by Fokit Delen and nothing else, my lord. They are resisting by taking this plea that the appeal is pending, and they have not moved that appeal or not taken any single step since 2019. And now when the bailiff has gone there and they have registered, they have seen the bailiff on the entrance gate, they have come up with this application. Now they are asking for stay and this substitution, and this is going on.
When was the appeal filed? 2019.
2019. On a decree is of 2019.
Then the appeal was filed within time. They filed it in the wrong
Appeal
link.
also not filed with. There is a condonation of delay application to their application.
What is the delay? 32 days will condone. Substitution cannot be because they were already on record in the trial court.
Exactly.
So we'll direct addition of party and direct the name of the original.
But substitution, they are asking Dilip Dey to be added as a party. Dilip Dey was already was a party to the when the decree was passed. They have not made him as a party.
In the substitution, they are seeking who has died.
Not Arati Dey.
Arati has
Died on 6th June 2012.
Junaki Ghosh.
Arati Dey is transferring in the degree.
Arati Dey is not transferring
No, no.
the decree.
Here the substitute. Ghosh is the Junaki Ghosh is the daughter.
Yes, daughter.
And who else are there?
Dilip Kumar Dey is the husband of Arati Dey. He's there. He was there in
Dilip Kumar Dey's name is transferring in the degree.
the degree. Dilip
But in
Kumar
the
Dey
memo
and
appeal,
Junaki
his
Dey.
name is not transferred.
And Dilip Dey's name is also not here in the.
You are not
application
seeking
they
to
have
impute Dilip Dey. Why?
filed. Yes, ma'am. That is the defect.
It was a defect, madam.
You have
How can
still
we-
not asked for
Still
Dilip
they
Dey.
have not asked for. That's what I'm.
You have
That's
stated
what
in
I'm
your
trying to
application Dilip Dey and Junaki Ghosh.
That's what I'm trying to say.
No,
They
no,
have-
no, 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 no. Please
This
come
cannot
to
be done.
para
In
4 of their application. They are now seeking substitution of Dilip Dey and Junaki Ghosh. Both. They are seeking substitution. Both We'll record your opposition, but we'll allow it.
Look at this.
Can 2 of
Very
2024
defective one.
is an application. Can 2 of 2024 is an application for condonation of delay in preferring the appeal. Full stop. Upon being satisfied that sufficient cause has been shown, comma, can 2 of 2024 is allowed, thereby condoning the delay in preferring the appeal. Full stop. The appeal be treated to be informed and be registered. Full stop. Next para. Can 3 of 2024 is an application for substitution of the heirs and legal representatives within bracket husband and daughter bracket closed of the original respondent Srimati Arati De, whose next para learned counsel for the plaintiff's respondents seriously opposes the application and contends that although Arati De died long back, comma, during pendency of the suit in the trial court and substitution of the heirs of Arati De had already taken effect in the trial court, comma, the appeal was filed deliberately in the name of a dead person. Full stop. It is submitted that by such ploy, comma, the appellants are seeking to protract the execution of the impugned decree. Full stop. Next para. Such contention is controverted by learned counsel for the petitioners. Full stop. We find that the appellants have failed to prefer the appeal against the heirs of the deceased Arati De, comma, although such heirs were already substituted in the court below and their names find place in the impugned decree. Push-up. Hence, comma, for all practical purposes, comma, the present application should not have been captioned as one for substitution, but as an application for addition of parties stroke leave to prefer appeal. Push-up next para, be that as it may, comma, we do not want to shut out the appellants on merits on such technicality, comma, more so since the heirs of the deceased Arotide are already on record in the suit, were already on record in this suit. Full accordingly, can 3 of 2024 is allowed, comma, thereby directing Sri Dilip De and Srimati Jonaki Ghosh, comma, the heirs. Jonaki Ghosh, Jonaki Ghosh is already on record.
Jonaki Ghosh is already on record.
Directing
Dilip Kumar De is not.
directing the impediment of Sri Dilip De, comma, the husband of the deceased Arati De, as a respondent to the present appeal. Push up next para. The necessary consequential amendment by impleading the name of Sri Dilip De as a respondent shall be carried out to the memorandum of appeal by the learned advocate on record for the appellants during the course of the day. So, yes, what is the other application?
My lord, for stay, my lord.
Stay of what? This is an eviction suit under which provision?
This is not an eviction suit. This is a suit for injunction, thereby restraining the defendants. Now they are the appellants.
What is the decree?
The decree is not to restrain the plaintiff to enter into the premises. That is the decree. And decree is executable under Order 21, Rule 35.
And that is
when
what
it is
we
against the
challenge.
immovable property.
No, you asked for a stay of the decree.
And how can there be a stay?
Please. You have asked for a stay of the decree.
Yes, madam.
How can an injunction decree be stayed? Let us see the decree once. The decree's mandatory injunction was also granted. Let us see what has been done.
Decree for declaration and for permanent injunction.
Permanent injunction. That permanent injunction.
Permanent injunction.
No, it has been held by the trial court that plaintiffs are in possession. And they have got a decree of permanent injunction. If you stay that decree, that operates as allowing the appeal before hearing it. We won't pass a stay.
So in terms of prayer C actually.
No question of any stay. If you prefer an injunction
One room,
application,
my lord. We are challenging one room, my lord, which was in.
whatever, 1 room, 2 rooms, we are not bothered with that. But since the impugned decree is a restraint decree, you cannot disturb their possession. If you stay that means you can disturb their possession, which we cannot do unless you win the appeal. You will be at liberty to file an injunction application regarding transfer, etc. We won't advise you on that, but stay, no scope of stay. We will dismiss the stay application. Can 1 of 2024 is an application for stay of operation of the impugned judgment and decree. Push up. We find that the nature of the decree is such which does not permit grant of stay at this stage. Pushed up, the decree is for declaration that the plaintiff stroke respondents are co-owners of the suit property and for permanent injunction restraining the defendants appellants from disturbing the possession of the plaintiffs in the suit property as co-owners. Pushed up, the effect of stay, comma, if granted, comma, would operate as allowing the appeal itself before it is finally heard out, comma, since the impugned decree is primarily in the nature of a restraint on the appellants. Full stop, as such, comma, we are not inclined to grant stay as prayed for. Full stop, accordingly, can 1 of 2024 is dismissed on contest without any orders to cost. Full stop, the appellants shall you are appearing for the plaintiff's respondents.
Yes,
all the Dilip De also you have instruction. Geeta De, who was Geeta De? She was a co-plaintiff, a co-defendant.
My
Pro forma defendant, who is Geeta De?
Gita,
You don't know anything about your appeal. You know.
For defendant
They
by
was
the
the pro forma defendant.
Arati De's mother.
Mother.
He is the pro forma defendant. He is one of the owner, co-owner.
She contested the suit.
No, yes.
Then we'll dispense with service on her. Your appeal will be expedited. No. The appellant shall put in requisites within a week from date, full stop. Service on the plaintiff's stroke respondents, including the substituted respondent, is dispensed with in view of appearance through learned advocate. Full stop. Service on the pro forma defendant stroke respondent is also dispensed with in view of the said pro forma respondent having not contested the suit. Full stop. Next para. The trial court records shall be brought by special messenger at the cost of the appellants, comma, to be deposited within a week from date. Stop. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Puts of liberty to the parties to mention the appeal for inclusion in the list as and when the same is made ready for hearing.
Is your
My lord, what will happen to the execution, my lord, which is on?
It will go on. You have to honor the injunction. Next.
The execution is on, my lord.
Yes,
And if-
next. Yes, please. Appropriate order means expeditious hearing.
No. Well, your lordship, can you see the impugned order? Well, I am for the husband who filed a application for divorce. Well, the wife contested
You are
initially.
for the respondent.
The appellant, your lordship.
This is Priyotosh Kumar Barman.
No,
Wrong number.
Sorry.
Yes.
Well, I am for the husband. I filed an application for divorce against my wife. Well,
Right.
wife initially contested. Thereafter, she refused to contest the application. As such, an ex parte order was passed. Well,
The suit was dismissed ex parte.
yes.
Achha, so what do you want now?
Subsequently,
Suit is dismissed. We cannot. There is no scope of stay.
that I know.
You shall we expedite the hearing? We will direct you to put in the requisite and prepare the paper books and all. What
Well,
else remains?
difficulty is that in the application I have stated some subsequent facts which are relevant for the determination of
Can one is you have prayed for setting aside the impugned,
Yes, because
which is not possible at this stage of it. You
Mm.
know that.
No. Well, actually, she got married to another person, delivered a child also.
So why do you want to proceed with this appeal? Just to harass her?
No.
Don't
Be-
proceed with the appeal.
Because I want divorce. So unless the divorce,
Oh, divorce has not been granted. She has married. You said. Oh,
Yes.
sorry.
after the divorce, he married somebody.
So serve a copy. Let us see if she agrees. She must be agreeing then. If she has
but
married,
she was not contesting the suit. That's the problem.
what is your present prayer in this application? Your prayer is for stay of that suit, stay of the decree, which we won't grant. We dismiss the application. If you want us to pass the necessary directions for preparation of paper books, your appeal will be expedited.
Hearing of
We'll
the
do
appeal,
that.
I
We'll
guess
do
like possible because I am suffering because
Obviously, you are suffering. The present application has been captioned as one for appropriate order for disposal of appeal, but in the prayer portion, comma, the appellant husband has asked for asked for setting aside the impugned decree. Push-up, if the said prayer is granted, comma, it would tantamount to allowing the appeal before hearing it finally on merits. Push-up, accordingly, we are not inclined to grant such prayer. Push-up, next para. Hence, can 1 of 2024 is dismissed without any order as to cost. Push-up, next para. The appellant shall put in the due requisites, including written up notice form, comma, declaration and tolabana within a week from date. Push-up, the trial court records be brought by special messenger at the cost of the appellant, comma, also to be deposited within a week from date. Stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Push up, liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Please prepare the paper books whenever it's ready, mention.
I'm grateful to you.
Thank you. This is your, yes, you're for the respondent. Yes, what is it?
By Mr.
What-
Aniruddha Chatterjee, he's online, Your Lordship.
You move the matter. Section 5, Mr. Anuruddha Chatterjee. What is your name?
Of Banerjee.
Can't hear you.
Shownok Banerjee.
Yes, Mr. Banerjee, move this. Section 5. What is the delay?
There's been a delay of
410.
days, Your Lordship.
So what was the degree which you are challenging?
We filed the reply. The reply.
Opposition you have filed,
They have filed the opposition.
previously filed.
Yes, sir. The direction was to file the opposition and the reply. File the reply.
Please file it. Why two oppositions to the stay and the?
Stay and the section.
We'll take up the section 5 first, obviously. Yes. So, no, you have filed only one reply.
No.
এটা আমার কাছে চলে আসবে। এটাও কেটে দিন।
ওনারটা তো আমারটা কেটেছেন, ওনারটা কাটেন। Don't look back. Look forward. Yes.
So maybe please grant a plus.
What is the decree you have challenged?
Your Lordship, it has been passed by the Under Code Barashat. Lordship, the documents, there have been few documents which we are challenging, which have been preferred by the respondents here.
You sought a specific performance of a particular contract.
Yes.
They got a decree.
Yes.
Very well. So did you file a counter claim?
Yes, Your Lordship, the respondents here, they do not reside in
No, you
India.
did not file a counter claim. What is a counter claim, Mr. Banerjee?
They just filed a WS, Your Lordship.
What is a counter claim?
I have any claim against the petitioner.
You have to pray for that specifically, right? You have not done that. So you have filed a written statement.
Written statement, Your Lordship.
So what is the reason for the delay?
Your Lordship, the main reasons have been that it is a changed brief, first of all, Your Lordship, and
Not
thereafter,
a good reason.
thereafter, Your Lordship, the petitioners reside outside India. So it is very difficult to communicate with them, and thereafter getting the documents.
Let us
and
see the
in between
relevant
there was
paragraphs in. Let us see the relevant paragraphs in your application for section under section 5.
Five.
No, he will continue moving the matter. Yes. The section 5 appears to be a prototype of the. No, this is a stay we are looking at. Section 5, yes. Please the relevant paragraphs.
5 and 6.
Your Lordship, kindly see
Mainly paragraph 5 and 6.
paragraph 5.
Five.
5 and 6, Your Lordship.
You have admitted at the very first sentence that you did not contact with the learned advocate. So there is no ground. Time period of delay is not important, but your conduct is.
No, paragraph 4, my lord, it's a continuation of paragraph 4.
Yes, paragraph 4 says what?
About
Paragraph 4 says there is a delay of for 10 days.
my lord, thereafter, my lord.
Was not able to contact with the learned advocate in view of the content.
Thereafter-
What is the ill health? That it
Sir,
could
that
not
is
continue
some-
for so many.
Yes, my lord, the problem is, my lord, that they stay, my lord, abroad and their power of attorney holder was in a difficulty. My lord, I'll also.
That is not stated here.
That's in the next paragraph.
Let us see that. Please sit, Mr. Chatterjee. Take your seat, Mr. Banerjee.
Lord, your lordship will find the petitioner further states that the petitioner did not contact with the learned. It should be could not. It's not did not. It should be could not. Contact with the learned advocate since long time, and on May 2023, the power of attorney holder of the petitioner Vikas Mauta informed the petitioner regarding the impugned order. So I was relying upon my power of attorney holder who was here, and in a Salt Lake property they have obtained a degree ex parte. On merits, my lord, I have a very good case before your lordship, because your lordship knows there is a line of decision that if, my lord, I have a meritorious case, my lord, section 5, your lordship would be more lenient towards it. But I
Right.
can't say that I was very, my lord, particular about my matter. I can't say that. I really can't say that. But I can show your lordship, my lord, from the order itself that your lordship would be a little lenient if the matter is meritorious.
What is the impugned judgment?
Yes, my lord, it's in the memorandum of appeal. Kindly have a look at.
Suit for specific performance was dismissed.
Allowed.
Decreed.
Allowed, agreed.
We have a look at the reasoning. My lord, your lordship will find that at page, my lord.
Mr. Chatterjee, suit for specific performance of contract was degraded in preliminary form.
Yes. Your lordship is absolutely, my lord. I bow down to your lordship's observation.
চান্স দেবেন না মেরিটে ঢুকে যাবে 5 এ কোনো এক্সপ্লেনেশন নেই তো প্যারাগ্রাফ 5 এ সেকশন 5 এ কোনো এক্সপ্লেনেশন
My lord, I really, my lord, it's basically, my lord, that I was completely not in the know-how of the suit. But even on that,
প্যারা 5টা দেখুন
my lord, if your lordship wants more particulars, I can, my lord, file a supplementary affidavit and bring in more particulars.
Mr. Chatterjee, you said that you place much reliance upon your power of attorney holder. Can you show any single line from the impugned judgment and degree that this gentleman, that your power of attorney holder, took active participation in the during?
That's what my point is, my lord. That's where I'm on, that I was not, my lord, represented correctly. That's where I say, my lord, even, my lord, takes it for granted, my lord, that I was not there. The plaintiff has to prove his own case. Sees, my lord, what's the
Probably
finding-
you do not understand my question.
Sorry, my lord.
My question is that you reside abroad. Your second point is that you depend upon your power of attorney holder. Your third point is that your power of attorney holder did not contact with your advocate.
My lord.
Is it? I believe these are your points.
My lord.
Our question is, from the impugned judgment and degree, can you show a single line from which it could be revealed that that not you but your power of attorney holder, more specifically that power of attorney holder, practically represented you and took a pivotal role in the suit.
Kindly have a look at, my lord, page 5. The written statement was filed.
Page 5 of the stay application.
Yes, my lord. Of the memorandum of appeal.
Page 5 of the memorandum.
হ্যাঁ বিকাশ মোতা ফাইল করেছি বিকাশ মোতা
So here, that is why, my lord, my point is before your lordship, my lord, that he was taking, my lord, whatever was being done in the court below, but I wasn't represented correctly. And your lordship sees, my lord, how the degree was granted. And I am, my lord, abroad. I have no, my lord, nothing.
Mr. Chatterjee, Vikas Mota has still filed this affirmed this affidavit also, but there is no explanation whatsoever as to why Vikas Mota could not do it.
So now he is here, my lord. Now I have got in touch with my lawyers here, and my lawyers are taking more active.
This application has been filed affirmed by Vikas Mota
Yes,
again.
sir, because it's all prepared by my lawyers now.
No, what's the reason for Vikas Mota
But your lordship, that is
not
what
doing anything for so long?
That's my point before your lordship. Lord, I am dependent on somebody else because I live abroad for my living.
No, you have to explain the inaction of that somebody else then. You are still depending, even after this delay, the Vikas Mota, the same person again affirms you are sticking to him.
I bow down.
What's the explanation for his inaction for 410
I
days?
leave, I'll explain that, my lord. But I know, my lord,
You're granted opportunity to file reply also. In the reply, you should have disclosed.
I understand the informative, my lord. I completely understand, but that absolutely unmeritorious, my lord, litigation will, my lord, see the fruits
No,
of it.
even then, Mr. Chatterjee, that can only be a consideration, provided prima facie you cross the first hurdle.
I bow down. Gives me a leave, I'll file a supplementary affidavit.
Yes, Mr. Rai, what do you say?
Lord, I would oppose, my lord, any prayer, my lord, for granting of leave to file supplementary affidavit, my lord, because the case, my lord, which Mr. Chatterjee is now seeking to make out, lord, ought to have been made out in the affidavit in reply, which they have now filed. This is a specific point taken by us in our affidavit in opposition, which could have been addressed, my lord, in the reply, my lord, instead of the affidavit in opposition, supplementary affidavit being sought for. Now, my lord, I would be, my lord, saying, which fell from my lords, that my lord Vikas Mota is still continuing. My lord, there is something, my lord, which is known as vicarious liability in cases, my lord, where third parties are, my lord, concerned. Here, my lord, the same person is being represented and he cannot, my lord, deny taking the responsibility of the negligence of the same person, my lord, with whom he chooses to continue even after the charge of negligence being leveled against the agent. My lord, here he has not been able to, my lord, contact with his advocate is one line. Second line, he says, I did not contact. Then he says, my lord, he depended, my lord, upon the constituted attorney. If it was through his constituted attorney, therefore, then, my lord, there was no reason for him to contact his advocate. His constituted attorney ought to have done it. My lord, there are 2-3 things being said in the same breath. We do not know which to rely on. We have answered all three. None of them, my lord, have been met in the affidavit in reply. If your lordship kindly sees this, my lord, the decree is passed, my lord, in 2021. My lord, he does not seek to explain even that, my lord, why he did not come there, why, my lord, he is residing. Kindly take, my lord, page 4 of the section 5 application. My lord, the paragraph begins at page 3, paragraph 3, and it continues. The petitioner further states that since the impugned order passed in amidst COVID period, and as such the petitioner should get the benefit of observation, such and such, and as such, no explanation for delay is required till 28th February 2022. Very well, my lord. This also, my lord, Honorable Supreme Court has said that, my lord, this taking of cognizance and extension of the period and, my lord, exclusion thereof is for the benefit of vigilant litigants. My lord, this litigant is so indolent that he did not take steps even after, my lord, the expiry of the extended period of 90 days, which was given after, my lord, this judgment of the Honorable Supreme Court saying that, yes, 90 days window will be given to them even after the extensions which ended on 28th of February 2022. My lord, if your lordship takes page 5, there is a chart given. My lord, the certified copy is applied on 18th of May 2023. My lord, 30th of May 2022 was the day on which the window of 90 days closed, granted by the Supreme Court, my lord, in the cognizance matter. My lord, take suo motu cognizance of the pandemic. My lord, 90 days grace was granted after the extensions, my lord, ended on 28th February. That period, my lord, expired on 31st of May 2022. My lord, almost 1 year thereafter, certified copy is applied for. And, my lord, the explanation is, I could not contact. And then the explanation is that, my lord, my constituted attorney did not inform. My lord, therefore, my lord, he had 2 contact points. My lord, what is his explanation for that? My lord, he has to explain why his constituted attorney did not inform him, because he is vicariously liable even otherwise.
No, why he didn't? I mean,
yes, definitely, my lord, because he is the face. The constituted attorney is actually the face, my lord, of the plaintiffs. My lord, if I take your lordship deeper, my lord, the constituted attorney at one point of time filed an application under Order 1, Rule 10, saying that the specific performance should be granted in my favor because there is an agreement between me and, my lord, the defendant. That application was dismissed, saying that no, you have a separate cause of action. My lord, it is actually a suit by the constituted attorney. My lord, they are only, my lord,
Facade.
yes, facade.
no, that's probably not correct. No,
But that is there. That is my case in the opposition.
but I can be.
Defendants. Both of them, my lord, were co-owners, my lord, of the property in respect of which, my lord, the specific performance was sought. One of them, my lord, has preferred appeal. Kindly have a look, my lord, at
Another has been added as a performer response.
and, my lord, kindly see the description. Kindly see the description. Both are being represented by his duly constituted attorney. My lord, kindly see here. My lord, this is the way, my lord, the suit is.
See where?
My lord, kindly see the cause title, my lord, of section 5 or of the state.
That doesn't mean, my lord, he gets a fruit of a degree which is not entitled to.
My lord, that decree has to be challenged in the manner, my lord, known to law.
I agree. I completely bow down. But
But
Mr.
even if it is a void decree, my lord, there are judgments which say that
if I show, my lord, the
a void
actions that
decree,
he's
if
done,
it is challenged beyond
my
the
lord,
period
his
of
client
limitation,
is done, my lord, your lordship will find, my lord, this is a complete case of fraud.
My lord, this fraud and all, everything, my lord, has to come within the ambit of limitation, my lord. Then limitation will never be,
Get
my
away
lord.
with something like
That is, my lord, Mr. Chatterjee's submission. My lord, I will answer it on merits, my lord, provided, my lord, this section 5 hurdle is crossed by him. My lord, I
That's
have
why
a
I
much
say
better case to run on merits.
I'm relying on those.
Ji. Sorry.
Sir,
We'll dismiss this section.
gives me a little bit of time.
No, no.
The lacuna.
Not after the reply.
I'll fill in the lacuna, my lord. Because
No. Precisely that you can do. You cannot do.
my lord, the Supreme Court now says, my lord, with a 410 days delay, they anyways, my lord, it's liable to be, my lord, allowed.
No, my lord. Just the otherwise.
It's the other way around, Mr. Chatterjee.
No, my lord, the Supreme Court, my lord, the ICICI Bank decision. And he remembers that. The Supreme Court.
No, Mr. Chatterjee, we are not
only in
inclined to
one line set aside the High Court's decision.
Can 1 of 2023 has been filed for condonation of delay in preferring the appeal. Full stop. Although the respondents claim that the delay is of about 485 days, comma, we proceed for the time being on the premise as taken by the appellants that the delay is about 410 days. Full stop. Next para. The impugned decree was passed on March 16, 2021. Full stop. As per the appellant, comma, the certified copy of the same was applied only on May 18, 2023. That is more than 2 years thereafter. Full stop. Next para. The explanation sought to be given is that the petitioner did not contact with the learned advocate since long time, and on May 2023, comma, the power of attorney holder of the petitioner, namely one Vikash Mohta, informed the petitioner regarding the impugned decree, and the petitioner immediately contacted his learned advocate. Full stop. Next para. Upon hearing learned counsel for the parties, comma, we find that sufficient cause for the delay has not been made out. Full stop. Next para. First, comma, we find from the affidavit portion of the present application that the same constituted attorney, namely Vikash Mohta, comma, who was allegedly responsible for the delay, comma, has been stuck to by the petitioner for preferring the instant appeal and the application. Full stop. Hence, comma, the reason for the inaction on the part of Vikash Mohta ought to have been explained. Full stop. It is even found from the written statement, comma, which is a part of the record and an annexure to the stay application, comma, we find that Vikash Mohta was the chosen constituted attorney of the petitioner all along. Full stop. Next para. In paragraph number 4, comma, 4 of the section of the application for condonation of delay, comma, the appellant stroke petitioner states that he was not able to contact with the learned advocate in view of the continued ill health and the fact that the petitioner is residing outside the country. Full stop. Again, comma, in the last sentence of paragraph 5, comma, the same statement is reiterated. Full stop. However, comma, there is a contradiction in the stand taken by the petitioner since, comma, if the litigation was being looked after all along on behalf of the petitioner by his constituted attorney Vikash Mohta, comma, who has also affirmed the present application, comma, there was no reason for the petitioner to contact his advocate. Full stop. Next para. If the said Vikash Mohta was responsible for the delay without any plausible reason, comma, it would have been reflected by the petitioner choosing some other constituted attorney and stroke or preferring the appeal himself. Full stop. Instead of doing so, comma, Vikas Mehta is still the chosen power of attorney holder of the petitioner. Full stop. Next para. We find in paragraph 5 that the petitioner has stated that he did not contact with the learned advocate since long time, comma, which clearly denotes that the petitioner was utterly negligent in conduct of his litigation. Full stop. Not a single sentence is mentioned as to what steps he took for at least contacting his power of attorney during the his constituted attorney during the relevant period. Full stop. Next para. More importantly, comma, not a single line has been devoted in the section 5 application or the affidavit in reply filed by the petitioner as to what prevented the said Vikash Mohta from preferring the appeal in time or taking steps in that regard. Full stop. Next para. it is well settled that although courts are generally lenient in condonation of delay applications, such lenience is extended only to vigilant litigants and not to people who deliberately abuse the process of court. Next para. In the absence of any explanation worth the name whatsoever in the application or the affidavit in reply for the delay caused in preferring the appeal, we are unable to allow the present application for condonation of delay as a matter of course. Accordingly, Can 1 of 2023 is dismissed on contest without any order as to cost, consequentially, FAT 348 of 2023 and the connected other application bearing Can 2 of 2023 stand dismissed as well.
Great for Jalacho.
Thanks.
Great.
Item number 5. It's appellant, my lord.
Appellants, yes.
Suit for declaration and partition of
You have
the
challenged the
portion.
preliminary decree or
My
what?
lord, my lord.
Preliminary decree has
My
been
lord,
challenged.
my lord, without
Appeal is in time.
My lord,
This is an application for stay.
my lord, please.
We'll pass the usual order. Suit will proceed. Final degree proceedings will go on, but no final degree will be drawn up. The present appeal has been preferred. The present appeal has been preferred. We won't touch that. The present appeal has been preferred against a preliminary partition decree. Next para. Upon hearing learned counsel for the parties, Can 1 of 2024 is disposed of by directing the trial court to continue with the final degree proceedings. However, no final decree shall be drawn up till disposal of the appeal. Stop. No orders to cost. Next para. The appellants shall. You are appearing for
1 to 6, my lord.
1 to 6, you say.
Right.
And what about the others? They are also required to be served. Partition suit. Very well. The appellant shall put in due requisites, including written up notice form and declaration for service of notice of the appeal on the pro forma respondent numbers 7 to 10. Service on the respondent numbers 1 to 6 is, however, dispensed with in view of appearance of the said respondents through learned advocate. Next para. The trial court records shall be brought by special messenger at the cost of the appellants, also to be deposited within a week from date. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Liberty to the parties to mention for enlistment as and when the appeal is made ready for hearing.
And upon notice. Liberty to mention upon notice.
That is there.
Item number 6, my lord, for the appellant wife challenging the divorce decree. But we have filed an application
Yeah, for the
stay of the second marriage.
Respondent, my lord, we had already, my lord,
There was a direction to file affidavit. They have filed their affidavit.
marriage has already happened, my lord, before, my lord, the stay application, my lord, to file. My lord wanted us to file, my lord, an
My lord,
affidavit to disclose, my lord, the marriage.
it requires some time to file the reply, my lord.
Can 1 has become perhaps infructuous, but my lord, I'll leave it.
No, my lord, because our
Infructuous.
our reply will, my
But
lord,
the
decide that
stay
whether
would-
it's irregular or illegal.
If they win, we'll direct restitution under section 142. Take instruction.
Yes, my lord, I have taken instruction.
Why ruin 3 lives?
No, my lord, I have taken instruction, my lord. My client wants to continue with this matter, my lord, and I required some time to file my reply.
Stay application has become infructuous.
That's what I was saying.
He's right.
But my lord,
We thought the appeal. You are
we
right.
have to put on affidavit, my lord, that they were on notice when they, my lord, conducted the second matter.
That can at best be a ground in the
There was a direction of your lordship to file reply, my lord. Kindly grant us some time, not much, my lord. A week's time will suffice, my lord.
Let them file reply here.
A week's time, my lord.
Whatever, my lord, I.
Learned senior counsel appearing for the respondent stroke opposite party, comma, at the outset, comma, points out that the respondent husband has contracted marriage in the contracted a second marriage in the meantime, and as such, the stay application has become infructuous.
This is the affidavit, my lord, directed us to file last.
Affidavit in opposition filed by the respondent today be kept on record. Full stop, next para. Learned counsel for the appellant seeks an extension of the time to file reply. Full stop. Next para. Accordingly, the time for filing reply is extended for a week from date. Full stop. The application shall be listed next on December 18, 2024 for passing orders.
Great. Great.
Thank you. None appears for the parties at the time of call.
Inform Mr. Sanjay Mukherjee is appearing for the appellant, my lord. His my lord is praying for a my lord accommodation for the day.
আচ্ছা বেরে তাহলে কেটে দিন ওটা an adjournment is sought on behalf of the appellant by the respondent.
The appellant, my lord. Yes.
By the respondent, you are for the respondent.
No, no, I'm for me. I'm not.
Adjournment is sought on behalf of the appellant. Let them attest and adjourn for the day. But you have to give your name. Somebody's name has to be there.
Number 8.
I appear on behalf of appellant.
ডেড স্পেসে করবেন না, ডাবল স্পেসে করবেন, আর একটু খেয়াল করে পাঠাবেন।
Sorry. Yes.
My lord,
This is appearing for the first time without any caveat.
first time.
What is the matter?
My lord, a delay of 9 days in.
Serve copy and come back. Serve copy of both applications.
I have moved this application. I'm just coming against an order refusing my ex parte addendum order. My lord, against that order, I'm before your lordship. My lord, I'll tell your lordship the difficulty what I'm facing with. My lord, it's a house where I'm residing. There are 5 brothers. I'm the 6th one. My lord, inside the house, one of the brother or the other brothers have put cameras exactly facing my room. But entirely excluding my privacy, my lord.
Is it possible to resolve among yourselves?
It can be sent to mediation. I will be agreeable
But
to.
they have to agree to that. Serve copies and come back. You are already diligent, non-diligent by 9 days.
I'm non-diligent by 9
If there was urgency, you should have moved within time at least.
What sort of injunction you have sought for?
My lord, not to operate. I'm not asking for immediately to take away the.
That's a very interesting question, actually. The CCTV cameras, you want us to put covers on the CCTV and put somebody there to watch it.
Not to operate.
How can it be implemented?
My lord,
Somebody has to be in your house.
my lord, I have to be done through my lord receiver because those are elected.
Instead of the camera, now the courts officer will be looking at your room.
My lord, the operation of the cameras can be stopped for the particular period, my lord.
They will look into that. Serve copies. You are late by 9 days. The petitioner shall serve copies of Can 1 of 2024 as well as Can 2 of 2024.
Can 3 also have filed because during the pendency of this appeal, your lordship, what has happened? They have installed one more camera.
Very well. Can 1 of 2024, comma Can 2 of 2024 and Can 3 of 2024 on the respondents, indicating that that all the applications shall be listed on December 23, 2024 under the same heading. Full stop, the appellant stroke petitioner shall file an affidavit of service to that effect on the next date. We are putting it this side of the vacation. That because you said urgent.
Very rare.
Item number 9, my lord.
Yes.
Difficulties, my lord.
Difficulties, Mr. Bhattacharya is appearing. That is one of the difficulties for you.
I filed as
Senior
put
person.
on record this matter. So I need to engage somebody to assist me.
Is it? Oh. Mr. Bhattacharya, you will appreciate that. Now he requires assistance. So come back when? Next Monday we are keeping it.
Yes.
You should have informed Mr. Bhattacharya beforehand. You should have informed him beforehand. You wouldn't be waiting here. Mr. Bhattacharya, this is a Section 5 application.
One Section 5, one stay, and
Mr. Bhattacharya will grant time till Monday. On the prayer of the petitioner, the matter is adjourned till December 16, 2024. 16th. Take steps in the meantime. No looking at each other.
Today I'll be giving my own name without any assistance. That's
Really amazing. Ask any of your junior to represent in the panel.
Yes, yes.
That would be
Ask somebody to be there.
Ah.
Even if not in the panel, somebody has to just pray for time. Ask her to give her name. Just say. Is she on the panel also?
Yes.
Very good.
We can direct her name to be regularized for today's appearance. We'll put that in our order. আরেকটা line add করে দিন তো. The name of the learned advocate seeking adjournment on behalf of the petitioner today be regularized by the appellant for today's appearance. Yes.
On behalf of the respondent.
You are for the petitioner.
I'm for the appellant, my lord. Because I'm prayingly, my lord, to file affidavit in reply, my lord. to the-
Opposition you have filed? Previously filed?
Yes, ma'am. Sir.
No, you have served. Have you filed? Let us find it out from there. Yes, sorry, it's there. Oh, আজকে file করুন. You are filing the reply.
Yes,
You have given copies to them.
Yes, ma'am.
You have given or you are giving?
I have given.
You have given. All right.
Is there a in opposition against the Section 5 application or stay?
In the team.
Section 5
Section 5?
application has been disposed of.
Section 5. Section 5 my lord was allowed.
There we are.
What is the appeal against?
My lord, against the my lord, granting of probate, my lord. Specifically fix the date of hearing, my lord. My lord, the actual matter was came, my lord, on their instance,
We
my lord.
cannot. Injunction, if you are prayed for, then we could have thought about it. But since you have prayed for stay, we are not granting stay. Very well, we'll pass necessary directions for.
Submit, my lord.
No, stay, he is not pressing the stay application. Are you pressing the stay?
Heard by another coordinate bench, my lord.
Which bench?
Presided over by his lordship, my lord, this is addition, ma'am.
So you should go before that bench then.
That bench is not there.
Appeal itself was heard substantially.
So far, my lord, as it reflects from the order, that matter was fixed for 4 orders. But
Paper books have been prepared.
may I explain what happened in this matter, my lord? We took a point that the appeal is not at all maintainable at their instance because they have no caveatable interest. They are claiming through the my lord, daughter-in-law who had not inherited anything under Section 15 of the my lord, Hindu Succession Act.
Achha.
So they have no caveatable interest. Although my lord, they were sent, citation was given, they contested.
Mr. Banerjee, we are not granting stay because it's a judgment in rem. We are disposing of the stay application, directing them to put in requisites and informal paper books. If you want, we can direct you to file.
This matter was hard, my lord. The honorable division was about to give judgment, but it was not made CAB, only for order.
Then it should go before that bench. Substantially hard also should.
Because it was not made part hard, their lordships released the matter. We mentioned before that bench, their lordships released the matter saying that we have not made it part hard. We took this point that the appeal is not maintainable at all at their instance because they have no caveatable interest. And no
Even
property
then,
has-
citation notice has been sent to them.
Yes.
And they have took participation in
Not
the
them, my lord.
trial.
Citation not sent on them.
The daughter-in-law, under Section 15, she has 13, she has no right not to.
No, what Justice Sen is asking, were they cited?
They were a party in the my lord suit.
You are right.
They were a party.
It has to be heard, Mr. Buster. Then we'll hear it along with the of hearing, you have not yet prepared the paper books. Will direct expeditious. How soon can you prepare the paper books when the records come?
Well,
4 weeks from notice. We'll make it 4 weeks from notice, and
Yes.
at the outset, learned counsel for the respondents takes an objection as to maintainability of the appeal, since according to the respondent, the appellant does not have any caveatable interest and as such has no locus standi to prefer the present appeal. Whose sub next para, such contention is disputed by learned counsel for the appellant stroke petitioner. Full stop. Next para. In any event, the question of maintainability of the appeal itself is kept open for being taken at the time of hearing of the appeal. Full stop. However, since the impugned judgment and decree is one for probate, which is in the nature of a judgment in rem, we are not inclined to stay proceedings, stay the operation of the same. Full stop. However, the appellant shall be at liberty to prefer to take out any injunction application if otherwise entitled in law. Full stop. Next para. Can 2 of 2023 is accordingly disposed of. Full stop. No order as to cost. Next para. The appellant shall put in. You are for all the. You are the only one. The propoundor. Very well. The appellant shall file requisites and put in special messenger costs within a week from date. Full stop. The trial court records be called for by special messenger. Accordingly, full stop. Service of notice of appeal on the respondent is dispensed with by virtue of appearance of the respondent to learned advocate. Full stop. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 4 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Next para. Liberty to the parties to mention for enlistment as and when the appeal is made ready for hearing. Affidavit in reply filed today be kept on. Affidavit in reply filed today সুব্রত প্রথমে করে দেবেন। আচ্ছা, প্রথম সেন্টেন্স, তারপর বাকিটা।
Only they have granted probate such that probate is affected that will be abide by the result of
Which is why we have granted you liberty to file application for injunction. What more liberty is to?
That is the law. It's sub judice. They are appearing. It has to abide by the result. If you set aside the probate, what else can they do?
Appropriate application from a portion book appropriate so advice.
I am the applicant.
Yes. This is appearing for the first time. No caveat. What is the appeal against?
Against the ex parte order passed by learned district judge.
What sort of order?
Against order of restitution of conjugal rights.
You have not filed any application under order 9 rule 13.
Petitioner filed written statement. One time learned
After passing of the ex parte degree, you file application under order 9 rule 13.
File, lordship file. This is a annex which is not entertained by the learned court.
Not entertained.
Lordship.
And this is a regular appeal against the main degree.
So it is till it is within time.
Within time, lordship. Kindly see the page 40, lordship.
So as the first impugn order. Impugn order, that is impugn ex parte order.
Impugn ex parte order 43, page number 43.
Page number 43 of
there is
the.
no whisper. Why?
Give us a second.
Learned
Page number 43 of the stay application.
Lordship. There is no whisper regarding why the learned court is to.
What is your application for under order 9 rule 13 then?
Lordship. Page number 40. Petitioner praying for vacating the ex parte order. There is no whisper.
Against a decree, against an ex parte degree.
Do they have any ground of difference?
Exactly. The appeal has been preferred against an ex parte decree granting restitution of conjugal rights against the appellant husband. Full stop. Being satisfied with the prima facie case having been made out, comma, the operation of the impugned judgment and decree dated July 25, 2024, passed by the learned additional district judge, 5th court at Barasat, district North 24 Parganas, in matrimonial suit number 16 of 2019, is stayed till disposal of the present application. Whose of the appellant stroke petitioner shall serve a copy of the present application on the respondent stroke opposite party at the earliest, indicating that the application shall next be listed for hearing in the monthly list of January 2025. Whose of the petitioner shall file an affidavit of service to that effect on the next date of hearing. সুব্রত পরে পাঠিয়েছে নাজিব আপনার সুব্রতিনের সঙ্গে 20 ওটা ছিল, সেটাও পরে এটা কথা। Yes, Mr. Ghosh.
Respond number 1B, my lord.
1B only. What about the others?
Expired, my lord. I have.
Who has expired? A.
1A has expired, my lord. One of the partners of my partnership firm, my lord. Pursuant to the order dated 1911, my lord, I have given them the information with respect to paragraph 5, the direction given upon me, my lord. And I'm the newly appointed advocate. I'm not the early asked for advocate who was appearing at that point of time, my lord.
All right, but what happens? What is the effect of death of A? 1A. What does the partnership deed say on the death of partnership?
The legal heir of the 1A.
Then Mr. Ghosh will probably have to impede.
The erstwhile learned advocate, we communicated the please furnish the names. But so far the partnership consisting of two partners, if one of them dies, there is no scope of reconstitution or the
No, if the partnership deed provides that his heirs will become the partners.
There is three partners, more than two, then only.
If there are two partners, if there is a provision in the if there is a provision in the deed, his heirs will become partners. Definitely, they are necessary parties.
So kindly see section 35.
Please, have you got a copy of that?
42C and 42C.
Let us once see that, Mr.
No, it is there.
We don't have anything. We can take it up tomorrow if you want. Bring the book and we'll. Partnership Act will be required. Anything?
Because also order 32, order 30.
CPC we should have. I don't know whether that's even there.
In the event partnership deed provides that if one of the partners died, the partnership will continue with the legal heirs of the deceased partnership. It will not suffice.
Not it appears from section itself that if there is more than two partners, because contract terminates upon death of the one of the partners. There is nobody.
Partnership definitely ends with the death of one of the partners under normal circumstances. But if the deed provides that his heirs will become.
Consider. That's why I'm telling you. But if
the partnership form has been constituted.
Yes, my lord.
That even, my lord, needs to be.
I provide the copies also, my lord.
Reconstituted formally by a new deed.
Yeah, by a new deed. I provided the copies also.
Have you disclosed that in your affidavit in opposition to this?
No, my lord. I'm seeking for an accommodation to file.
That's why I'm not requested them to provide us with their on the original deed of partnership what it contains. They have not furnished it. That's why, my lord, we could not.
You have what is the impugned decree, Mr. Ghosh?
The suit for specific performance has been dismissed. Against that, we have prepared an appeal.
This, you are asking for injunction. You are filing a reply against what? They have filed in opposition.
Respect to myself, my lord, I'm seeking for an accommodation of a week's time to file affidavit in opposition, my lord. I'm newly appointed advocate.
Mr. Shane, you are for which?
3 and 4. Respondent numbers 2, 3 and 4.
Very well. Mr. Ghosh will give that liberty to them. In the meantime, we'll direct we'll pass injunction.
My lord.
But so far as injunction, we have filed in opposition.
What do you say to that?
Requirements made in the application paragraph 21 and 22, page 14.
Page 14 of the stay application.
Yeah. That's the documents have been filed or they have made complete against the person, nothing has been added. Only environment is there, as part of the
So on the basis of the part performance of the contract, you have been put into position.
Yes. As
But,
constructed,
and you are now
possession thereof. It has
Mr.
been
Ghosh,
found-
please listen to my question. You are apprehending your disposition.
Yes.
That is your case.
But so far as they have made recovery of possession now. In the suit,
No, recovery of possession, but during pendency of the suit, they forcibly took possession of 2 flats from behind, cutting the, that was brought on record of the learned court below and sought for recovery of possession of that portion only. Entire building is in my possession, admittedly.
Then regarding those 2 rooms, you cannot have this injunction.
No.
You should have disclosed that in your.
They cannot interfere with my possession. That's I have to. I have that.
Mr. Ghosh, regarding 2 rooms, you are admittedly dispossessed.
Yes.
You cannot get a repossession by virtue of getting injunction.
No, I'm not.
You should have disclosed those 2 rooms regarding those 2 rooms in your
2
injunction.
flats, Lord, I have said in the
Where?
application also.
Where have you said that?
Man, that apart, Lord, kindly see.
Where have you said in your application? The 2 flats you are disposed of 2. Because you have paid for injunction regarding the entire suit property.
pendency of the suit, there was no injunction. In spite of the suit being specific performance of contract.
No injunction. They did not challenge that refusal.
You lordship kindly.
No injunction of my instruction is
No injunction application filed.
Lord, your lordship kindly come to paragraph 20 of their opposition. They says, what they say. The answering defendants state that they undertook not to do any illegal work during pendency of the suit, and there is no reason of such apprehension that the petitioner will be ousted from the illegal possession. Mere apprehension cannot be grounded. If Lord they says that I will not do anything, then we have nothing to say during pendency of the appeal. Lord, so far their dispossessed portion is concerned, Lord, we are not praying anything. Let them be there.
Learned,
Kindly may have an opportunity to.
yes, we'll give you that. We'll give you that opportunity. Learned counsel appearing for the respondent number 1 within bracket small b submits that respondent number 1 within bracket small a, comma, one of the partners of the respondent hyphen partnership concerned has met his demise. First of next para, it is further submitted that the partnership has been reconstituted accordingly. First of next para, learned counsel also seeks a weak apostrophe accommodation for filing the affidavit in opposition of respondent number 1 within bracket small b. Push up next para, learned counsel appearing for learned senior counsel appearing for the petitioner contends that the petitioner was put in possession pursuant to the agreement, comma, the specific performance of which has been refused by the trial court. Full stop next para. Accordingly, the petitioner seeks an injunction in respect of the suit property in respect of possession. Full stop next para. Learned counsel appearing for respondent numbers 2, 3 and 4 submits that during pendency of the suit there was no injunction, no subsisting injunction. Full stop next para. That apart, comma, the said respondents do not intend to disturb the possession of the petitioner. Full stop next para. Learned senior counsel for the petitioner also points out that in the affidavit in opposition filed by the respondent numbers 2 to 4 itself, comma, it is mentioned that the said respondents undertook before the trial court not to disturb the possession of the petitioner during pendency of the suit. Full stop next para. It is also submitted by learned counsel for the respondent numbers 2 to 4 that admittedly, comma, the petitioner was dispossessed from 2 rooms, comma, according to the petitioner during pendency of the suit, and as such there cannot be any injunction regarding possession, at least in respect of those 2 rooms. Full stop next para. Upon hearing learned counsel for the parties, comma, we find that a prima facie arguable case has been made out by the petitioner sufficient to protect the present possession of the petitioner. Full stop. Accordingly, the parties shall maintain status quo in respect of possession of the suit property as of today, till disposal of the application, full stop, the respondent number 1 within bracket small b shall file his affidavit in opposition to the injunction application within a week from date. Full stop, reply thereto, if any, shall be filed by January 3, 2025. Full stop, the application shall be listed for hearing on January 7, 2025. Full stop, next para. The affidavit in opposition filed on behalf of the respondent numbers 2 to 4 and the reply thereto filed today be kept on record. Please circulate copies of your opposition to Mr. Shen also, so that they can also come prepared. Obviously, you will give to Mr. Ghosh's Jr. and to them also.
Item number 13.
None appears for the parties at the time of call. Let the matter stand adjourned for the day. Record করে রেখে ইচ্ছে করে দেবে, one night. বোঝা যায়। হ্যাঁ, ঠিক আছে।
Item number 14.
14, my lord, this city code appeal, the current.
I'm for the respondent, lordship.
All right. City code FMAT. Yes. This is against what, Mr. Bhatt?
Section 5 application is there.
Section 5 you have
First time.
Oh, you have to give a copy of the section 5.
Yes, sir.
Serve a copy, come back when? Next Monday? What is the delay, Mr. What is it?
31 days.
We can keep it tomorrow also. Come prepared tomorrow.
Grateful.
We'll dispose of the section 5, take up the order 41, then we'll.
The lordship kindly direct us of the stay application.
In that event, my
We'll direct
There is no
memo.
there is no caveat. I am accepting.
No difficulty in that. We'll direct the memo and both the applications to be served.
for our matter, there is another appeal, my lord, I have not mentioned it, my lord. Subsequently, ad interim order has been extended. I am giving that number, let it also appear along with that.
Very well, but extension, if this goes in the, very well, that should appear.
That should have been since.
That is also a delayed filing.
No, that
is in time. So you'll serve, what is the number?
That is, my lord, 350 of 2020, FMAT.
350 of 2024. Please ask your junior to write on a piece of paper also, so that it's not me. Is there any application in connection there with?
Yes, stay application.
Can one?
There is only can one.
We'll serve everything lock, stock, barrel to them. Come prepared on everything on Monday.
To address a phone number.
Pardon?
When it will appeal.
Monday we'll keep. Learned counsel appearing for the petitioner points out that there is a that another appeal has been preferred against a subsequent extension of the injunction order, which is impugned in the present appeal. Whose next para, we find from the records that the present appeal is accompanied by an application for condonation of delay as well as a stay application. Pushed up in order to expedite the matter, the petitioner, the appellant stroke petitioner shall serve copies of can 1 of 2024, can 2 of 2024, as well as a memorandum of FMAT number 349 of 2024 to the learned advocates having instruction to appear for the respondents who are appearing in court today. Pushed up. Next para. The appellant shall also serve copies of the memorandum of FMAT 350 of 2024, the connected appeal, and can 1 of 2024 filed in connection with the said appeal on the learned advocates having instruction to appear for the respondents. Such service shall be effected by tomorrow. Both the appeals and the connected applications shall be listed under the heading Order 41 Rule 11 of the Code of Civil Procedure on December 16, 2024. We'll treat the section 5 to be an application in connection with Order 41.
All applications and memo.
All applications, memo, everything served by tomorrow, if possible by today.
Yes.
So that they can get prepared, and injunction appeal we can probably dispose of also if you come prepared.
The suit has become infructuous. Your lordship will observe that and.
Very well, sir. You are there, you just point out when you. এটা কিন্তু order 41 heading আসবে along with the applications. Thank you.
Years of defendant number one is the appellant before the option. They applied for the first time. I will serve of the party and another order I seek that I should serve upon the learned advocate appearing for the who used to appear rather in the court below because none of the except me none of the parties are staying in the residence suit property. So and I don't know the address so far as the sanitary respondents are concerned.
No, but he does not. We cannot saddle him with that responsibility. That will be cruel. If you don't know the address, the advocate is.
So far as the other
Case is over, client has taken brief, why should that?
But difficulty is it will come back answer.
You have to ascertain the
But I
current
wrote to the other respondents, that is annexed letter to the other respondents regarding.
employ a private investigator, Mr. Shen.
One second.
You have to ascertain. You are the appellant, it's your headache. So should we take it up on some other day so that you can ascertain the address? Meaningless service, unnecessary postal costs. We'll record that you have been instructed that the addresses of some of the respondents has altered. So we'll grant you some time to ascertain the current addresses and keep it whenever you say. We'll do that so that you can correct, we'll permit you to correct and then serve at the proper address.
But so far as the respondents number 4, 5, and 6, their address is known.
No, but even then, Mr. Shen, then we have to serve on all. We cannot direct piecemeal service.
Let me come back.
I think that will be better. Unless your client has money and you want to spend more on postal costs, you have extra money, then we can direct service now and again after ascertainment. Learned counsel for the appellants, in his usual fairness and on instruction, submits that the addresses of some of the respondents might have altered in the meantime. Full stop. Accordingly, in order to enable learned counsel to ascertain the current addresses of all the respondents, the matter is adjourned till when? After
Coming Wednesday.
that will do. Very well. Till December 18, 2024, when the application shall be listed under the same heading.
Milord, I am for the appellant, Milord. Milord, as per the direction of the registered administration, Milord, there is deficit quantity of 90 rupees in term of the SR.
90 rupees you have put in subsequently?
No, Milord, the registered order took place before the Honorable Court for necessary order, Milord. It is the
Where will direct you to file deficit, put in the deficit code, please?
It's condolation of 19 days, and one mistake was there that it is typed as a FMAT, but it will be FAT, Milord.
What is this the challenge against?
The order of the primary degree of the partition.
Preliminary degree. Yes, very well. So where is can 1? Can 1 we confirm? Can 1 ta paচ্ছেন?
Can one is for
1 ta stay, 2 ta paচ্ছেন? You have filed an application for condonation. What is the number?
Can 1, Milord.
Can 1 is stay?
No, sir. Have you filed any application under section 5?
No, Milord.
In terms of the.
No, Milord.
So you have
Condonation, you said yes?
No, Milord. It is a stay application as the commissioner is.
There is a delay also.
Yes, Milord. For of 19 days, Milord.
So file a section 5 application.
Yes, Milord.
Stamp reporter has reported
Deficit code fee dite bolbe.
19 days delay, deficit code fee, as well as from
FMAT classification.
FMAT classification.
Yes.
So you regularize this matter.
Yes.
We find from the report of the registrar administration within bracket L and OM bracket close that the appeal is defective for 3 reasons. Full stop. First, it has been filed out of time. Secondly, there is a deficit court fee, and thirdly, the appeal has wrongly been classified as FMAT instead of FAT. Full stop. Next para. In the memorandum, you have classified correctly. Let us see that. First memorandum. What is first memorandum of appeal tender? Oh, FMAT.
এফএটি হবে।
First memorandum of appeal. Please score through this within bracket first memorandum of appeal tender. There is nothing of that sort. It's first miscellaneous appeal tender, but it's wrongly classified. You scored that through. Please come to your memorandum.
Yes, my lord.
See the first page, that is the back sheet. You're looking at the back sheet. Yes.
Memorandum of
First memorandum of appeal tender, score through the entire thing. Write there, appeal from original decree. Do that and write beside it after signing, amend it with the leave of court. We are granting you the liberty and put in the deficit court fee and file section 5. So next para, accordingly, leave is granted to the appellants to file an application for condonation of delay in filing the appeal, as well as to put in the deficit court fee within a week from date. Push up next para. The learned advocate on record appearing for the appellants is also granted leave to carry out the necessary correction in the memorandum of appeal by scoring through the expression within double inverted পুরোটা ব্লক লেটারসে ব্র্যাকেটের মধ্যে ফার্স্ট মেমোরান্ডাম অফ অ্যাপিল টেন্ডার ব্র্যাকেট ক্লোজ ডাবল ইনভার্টেড ক্লোজ and inserting within double inverted appeal from original decree double inverted close push up such amendment to the memorandum shall be carried out during the course of the day. Pushed up let the matter go out of the list for the present with liberty to the appellants to mention the application for condonation of delay comma if filed. এটা out of list হয়ে যাবে. When you file the section 5, mention it, we'll take it and allow it or decide it.
Appeal number 17.
কন্ডোনেশন অ্যাপ্লিকেশনের লোক নেই, লিভ দিয়ে দিয়ে অনেকগুলো ভুল রয়েছে। 2248 দিনের ডিলে ডেফিসিট কোড the appellant is directed to cure the defects as pointed out in the report of the registrar administration within bracket L and OM bracket closed dated November 28, 2024 within a fortnight from date. Pushed up. Let the matter be listed under the heading to be mentioned in the monthly combined list of cases for the month of January 2025 for passing final orders.
my leader would be that I'm told online.
Mr. Chatterjee, yes.
That matter will not where.
Yes.
Question has arisen whether they are entitled to pay occupation charges or at least
Yes.
for them. I have made my submissions on two things I need to indicate which I have found out subsequently. Millard, your lordship thinks the opposition wants, although Millard, yesterday your lordship had indicated to me that your lordship is less inclined to look into this document at this stage.
Yes.
But Millard, if your lordship comes to my opposition at page 59.
Yes.
Millard, according to the landlord, Mihir law, this was the position. If your lordship comes to Millard, file the suit. Yesterday I told your lordship the written statement, your lordship said that written statements may not be accepted, but now he's also filed a suit, which was also there. In his suit, my lord, if your lordship comes to 59, the lordship will find
59 of stay application or affidavit in opposition?
Millard, affidavit in opposition to the stay application. Millard, all four parties are here. Mohan Singh is there, predecessor interest. The judgment data Zahil is a defendant number 2. Jenny Christian, my client, is defendant number 3, and International Club is defendant number 4. There are only 3 statements. Paragraph 2, minute at 860. At all material times, the defendant number 1 and 2 were and still are the residents in apartments situated in the first floor in the main building of the premises number 42 Shakespeare Sharoni, and are occupying the same as licenses under Messrs. Jenny Christian Apartment Private Limited, the defendant number 3 here. That's the stand of the landlord. Now, paragraph 4, Millard, if your lordship goes further, pursuant to in terms of the lease, the plaintiff and his father deceased allowed the club, defendant number 4, to sublet the first floor of the main building of the said premises, demised to the said club, defendant number 2, to the defendant number 3. The defendant number 3 had been and still is a tenant under the club in respect of the first floor of the main building, premises paying a monthly rent of 1,000 to the said club. The reason why I say this is, while deciding on the question as to occupational charges, my existence and the existence of the judgment debtor through me is admitted by the landlord. So therefore, the question is, if my learned friend says that he was in possession, which Millard, the bailiff ultimately found that he was not, then there, Millard, either he has to come through me or through Zahid. If he is opposing a decree under Order 21, Rule 97, saying that it's not executable, then Millard, his interest is either through Zahid. If it is through Zahid, Millard, then he is supposed to deposit the occupation charges. Number 1. Number 2, Millard, so far as my learned friend is concerned, though this is not on record also, Millard, it subsequently transpired, Millard, my learned friend says that he has been paying rent to the landlord. And he has annexed in his stay petition, page 52, a receipt where he shows 52A, where he shows of the stay application 52A, that this is the mode and manner he says that he is paying rent. Your lordship sees letter, it is addressed Maninder Singh such and such, Mihir Kumar Law, date is 29 January 2016. And he says, I am paying this, PDA check number such and such drawn on bank. So he is paying it by way of check to the landlord in 2016. Well, my clients have revealed that Mihir Law has died in 2005. 2007. This is the death certificate.
You cannot take this on record.
I know that.
Sir, you cannot rely on documents, particularly in a.
So therefore, Millard, yes. So therefore,
Another document comes up from somewhere.
We cannot look into it.
No,
You are
no,
right.
I just Millard. So Millard, this is the situation here. So it's basically.
Sir, I'm sorry.
No,
You are referring 52A.
52A, Millard, but right now, Millard, lordship need not go into it because 52A shows that a check is being paid in the name of a person who has died 15 years back.
A fact which is not on record, Miller, Mr. Dotto would not
know
make
that
you try
this
and-
is your this is.
Mr. Chatterjee has got his.
No, it is not.
It's his disclosure.
His disclosure.
Mr. Chatterjee, don't be so vociferous after we turn down the document.
52A was his disclosure.
No, it is the case of the Mr. Chatterjee's client
that he is
paying rent directly to the landlord.
Could not be. That's what I'm trying to say.
So, in support of that, what document he has relied upon?
Yes,
This document.
Which is a
payment of rupees 22,500
in 2016.
In 2016
And
to Mr. Mihir Kumar Law.
And Mihir Kumar Law passed away in 2007.
Again.
We'll come back in 5 minutes, Mr. You reconcile this thing with Mr. Chatterjee. The death of Mihir Law.
Thank you.
Yes, Mr.
In this factual situation, the last submission that I need to make, Miller, the principle of Atmaram and cases that have followed is that
Take the microphone, sir.
I'm sorry. The principles for Atmaram Miller and the subsequent judgments that followed that is that if I have toiled hard to get a decree, spending a substantial period of time, and the judgment debtor has a right to have it tested, the law gives him that right. He has a liberty to do it. But at the same time, he cannot enjoy the contractual because that has been adjudicated once against him. So that's the protection which this principle of Atmaram is.
So it's the decree holder who is being prejudiced and who suffers.
Yes.
So that he has to be compensated.
Yes. So therefore, here, Miller, my learned friends stand under Order 21, Rule 97 have been tested once and have not found to be substantial. He has a right to appeal, Millard. That law gives him a right. But at the same time, Millard, the interest of Millard, my client, should also be protected in a suitable manner. Those would be my submissions.
Right. Yes, Mr. Chatterjee. Where is he? So, Banerjee, you can start.
My lords will kindly, my lord, first appreciate, my lord, the...
Lord, my
Yes.
lord's kind pleasure to hear me tomorrow in the morning.
No, no. We're in the midst of this, Mr. Chatterjee. No.
Lord, but I'm in real difficulty. Or at 2 p.m. today? 2 p.m.?
Mr. Chatterjee, Mr. Banerjee is your able assistant and he is here to rescue you in case of your...
I'm quite sure on that. But 2 p.m. today, if it commences, your lordship at 2
Mr. Chatterjee, we request you to please proceed.
I'm in the midst of an argument in another court. That's my problem. But I'll give your lordship. I can come at 2 p.m. physically before your lordship.
Your physique is not very appealing to us.
I agree, my lord. That's
Your
completely
presence
right.
will do. Your presence will do, Mr. Chatterjee. You need not come physically, but are you sure that matter will be over by 2?
I'll come before your lordship at 2 p.m.
Depends on what Mr. Dotto says.
Hey, Mr. Dotto will say, my lord, he's in my favor.
He's saying no.
And no, but
he has no objection to that. Come back at 2 then. Very well.
My lord, so grateful to your lordship.
Passover is a treat. Your argument is over for the time. Yes. We'll hear Mr. Chatterjee. You don't need to tell 8. $19.
20.
Yeah.
Sir, yet to go through the Order 41 stage. These are appearing in the application.
Not City Civil Court.
Not City Civil Court. Alipur Court.
The 19 and 20 দুটোতে separate order করবেন let the matter go out of our list due to lack of determination with liberty to the parties to mention for inclusion before the appropriate bench.
Lords.
আমাদের কাছে order 41 City Civil Court irrespective of year যেহেতু just stand
At 21, my lord, I am praying for 15 days time, my lord.
No, why 15 days?
My lord, at that time, my lord, I was a junior and my senior have filed this case, my lord, and my senior is not coming to the court, my lord.
You are capable enough, Ms. Rani.
I have and I have no contact with the client, my lord, since decade, my lord.
Very well. बहुत infectious है वैसे. Very well, keep it after the vacation then. Learned counsel for the appellant seeks a fortnight's adjournment in order to enable her to contact her client. Push up next para. Keeping in view that the appeal is an old one, comma, we grant such adjournment. Push up. Let the matter be listed under the same heading in the monthly list of January 2025. Mister? He has not come to court. We'll record your name and grant an adjournment. On the prayer of the appellants, let the matter stand adjourned for the day. Just give it on a slip of paper. Give it on a slip of paper.
Appeal number 23.
What would I for the appellants?
Question for the respondent, Lordship.
My lord, in this matter,
Matter, Lordship, I have to contact with my client's Lordship.
It has crossed the, or no, it is still, it is for order for Rule 11. It is against injunction, Mr. Bhattacharya.
no, my lord.
Miss appeal?
Junction, nothing.
My lord, I am praying for custody.
Custody matter.
Custody.
Then immediately after, even if we admit it, we have to hear the application.
It is an appeal of the year 19. And the child has not attained the majority.
Yes, I was also thinking that.
As per the application, she is 12 years probably. 6 years old at the time of 2019.
When should you keep it?
I have to contact with the client and have to bring the
Contact immediately, just give a phone call.
The number has been changed. Like yesterday,
Mr. Bhattacharya, ask your client to furnish the number of their client.
I tried yesterday. Phone number.
Other side phone number? No, I have no. But I have got the phone number of my learned friend.
Won't do. No use phoning her.
It's a serious matter. Kindly consider on us. My lord, I married a girl on 14 August 2011 without knowing that she was involved in Rose Valley cheat funds deposits. And I also did not know the depositors of Rose Valley cheat funds were disturbing her for recovery of money. Marriage was solemnized. A girl was born on 16/11/2012. Even after birth of a girl, the wife used to visit her mother's house, where from she used to do her business in cheat funds. The depositors started visiting her mother's house and asking the mother and brother to bring the daughter and to face them. We do not know anything. Ultimately, she committed suicide, like his father. His father or her father also was involved in certain other matter. He also committed suicide. Her uncle also committed suicide earlier. She committed suicide in my house, which is a bolt from the blue, for which my entire family was put to criminal investigation on an FIR filed by brother-in-law. We are all arrested. Thereafter, we got the bail. On that very day,
the brother-in-law took the girl who was 4 years old at that point of time to their house in a different village. From that particular date, I have no connection with my daughters.
Mr.
I could
Bhattacharya,
not
this
be
appeal
able
was filed in 2019. Why didn't you get it admitted at least under Order 14 Rule 11 for so long? For these 5 years?
Learned judge did not fix the date and
For
time.
5 years. Order 14 Rule 11 matter.
Learned judge committed wrong. And also learned judge.
Why didn't you get this Order 14, this your appeal? Hard and.
My lord,
we thought the learned judge of this court committed wrong in not.
we mentioned the, I cannot.
5 years Order 41 matter
Could not be listed.
should have been listed.
Because,
If there was so much urgency, you should have had it listed. Let her contact her client and come back with instructions, Mr. Bhattacharya. She's asking for a fortnight's time.
No, I am not at this point of time. I am not opposing her to pray for time.
Oh, you opened the matter
I am
without that.
only submitting before your lordship.
Unfortunate
That this
case,
is
turned
a
out.
fact.
Unfortunate.
Whether, and in the meantime,
Give us a
the
second.
trial court this, your lordship, this is an appeal under order section 47.
Right.
Then your lordship may admit the appeal and stay petition. I file an application for the custody. For that, instruction need be taken by Learned Pen. With regard to admission of appeal, whether it is necessary, your lordship can.
Admission not
Okay.
Yes, good.
Or both should be heard.
We'll admit the appeal formally, not take up the injunction application. We'll take up the applications after application. We are admitting.
Kindly give me liberty to file the opposition against the
Application.
Application for what, ma'am?
interim custody lordship.
1 and 2.
I rely upon the documents. I will not make any statement from.
So, Mr. Bhattacharya, to save time for your client also, we'll direct the affidavits to be exchanged in the meantime. So that it comes prepared, we can take up the application on the next day. Since the present appeal involves questions of both fact and law, we are satisfied that a prima facie case for hearing of the appeal on merits have been made out. So accordingly, the appeal shall be heard on the questions raised in the memorandum of appeal. Push up next para. On the prayer of learned counsel for the respondent, to enable her to take instruction from her client, the applications bearing can 1 of 2019 within bracket old can 12558 of 2019 and can 2 of 2021 are directed to be listed on January 13, 2025, full-stop. Affidavits in opposition, if any, shall be filed by December 24, 2024.
One submission I have got.
No, shall be filed by January 3, 2025. Whose reply, if any, shall be filed by January 10, 2025. Yes,
I
Mr.
will pray one prayer, my lord.
Yes.
I want to file a supplementary affidavit annexing the evidence given in the sessions trial. I want to file.
How soon can you prepare that?
By Friday. This Friday.
Leave is also granted to the appellant to file a supplementary affidavit on the next returnable date. However, such supplementary affidavit shall be affirmed by the appellant by December 13, 2024, and a copy thereof shall be served in advance on the learned advocate for the respondent by the said date. The respondent shall deal compositely with the application and the supplementary affidavit in her affidavit in opposition. Thank you. আর ওই পেপার কোনোদিনই হবে না, হ্যাঁ? Mr. Bagji, they are repeatedly being absent, so now they should suffer.
You also know what is there.
No, no. We find from the records that the appellants are repeatedly unrepresented when the matter is called on for hearing, full stop. The respondents, however, are all along represented through counsel, full stop. Accordingly, FA 120, is there any connected application? Do you have any idea? Accordingly, FA 122 of 2018 is dismissed for default, full stop. All pending connected applications, if any, also stands disposed of accordingly, full stop. Interim order, if any, stands vacant. No address to cost.
Item number 25 to 26.
Canton nahi. Good.
For
Indicating which code? 4. Just write on a slip of paper so that we can bring the can. I think that will be, because the appeal is up for hearing.
Yes.
You can take up the appeal also, but what is the can for?
Can for is the
Order for 227.
no condonation of delay. Since we have taken out a court.
Oh, then that has to be heard. Right. We find that can 5 of 2024 is not with the records, full stop. The learned advocate for the respondent is requested to, you are for the respondent.
Yes.
Learned advocate for the respondent is requested to furnish the particulars thereof, full stop. Let the said application be tagged along with the main file on December 16, 2024, when the matter shall next be listed under the same heading. Please give the particulars, particular dine requisition kore deben ekta court.
Who is for the respondent?
O respondent, ora cross objection file korbe.
Respondent.
Appellant name. Order at a line at the learned advocate appearing for the respondent is requested to intimate about the pendency of the appeal before this court to the learned advocate on record for the appellant in the meantime, and file a receipt on the next day. Thank you. Perfect.
I'm from the appellant. On the last occasion, I submitted my letter to your lordship that
অভিজ্ঞতা খুব ভালো. Yes.
that after my lord the disposal of the stay application, my lord, there was no contact with my client. My lord, subsequently, my lord, that has been made.
Contact has been established.
My lord, paper book also has been, my lord, prepared, and my lord, only thing left is, my lord, for the appeal to be heard out. The only thing, my lord, I'll just indicate.
Paper book has been filed.
No, yet not filed, my lord, not filed. My lord, prepared, my lord, served on the other side as well.
So we can take in court also. We can take the paper.
Yes, difficulties, my lord, not.
Those are not with you, no.
Not with me at this moment.
Then we will keep it on 17th because.
My lord, in the meantime, my lord, only one, my lord, copy of cross-examination has been, my lord, left out in the main paper book. My lord,
Directed to file a supplementary, give a copy to Ms. Rani. Learned counsel for the appellant submits that some documents have been inadvertently omitted from the paper book. Full stop. Accordingly, the appellant shall prepare a supplement, prepares the requisite number of supplemented affidavits incorporating the omitted documents and hand over a copy in advance to the learned advocate for the respondents before the next returnable date. Full stop. The appeal shall be listed next under the same heading on December 17, 2024, when the appellant shall file the paper books and the supplementary paper books in court.
my lord, mention supplementary affidavits. So the
Oh,
supplementary
sorry. Supplementary affidavit যদি কথা বলতে গেলে paper book. Thank you.
Great.
Item number 28.
28 অন্য দিনে
19 তারিখে আছে
19 তারিখ ফিক্সড আছে লিস্ট।
Item number 29.
29, my lord, I am appearing for the appellant applicant.
আমাদের আবার দুটোর সময় বাপির জন্য
Against a decree of divorce on the ground of cruelty, my lord, there is an interim order, my lord, for payment of maintenance, alimony pendente.
not paying.
No, my lord, I am not getting, my lord. 3 months they have paid, thereafter, my lord, they have
An application for implement.
I have filed, my lord, the can is there, my lord.
Can is there?
Can 3 is, my lord, for attachment of his salary.
Have you served a copy
Yes,
on?
yes, I have served a notice also, my lord, just last week, my lord. May I place it before your lordship? My lord, this is
Last week you have served a notice?
yes, well, can this is. And I have served the copy of the application also to him, my lord. This is the, if your lordship. Application.
Application.
Where is the order? My lord, may I take your lord, page 102 of the paper book.
Paper book means?
Lord, this is the interim order, my lord. 4/4/2024. Page
Paper
102.
book application টা বার করো. What is the application?
Can 3.
Can 3 টা একটু বার করে দিন.
Which page, sir?
Page 102. Suit has been decreed on the ground, my lord, that since there is nothing on record to disprove the allegation of cruelty, so therefore cruelty is proved. Yes, well, kindly seize the order, my lord, passed by.
There's an issue. You have an issue. Child.
No, no, no. My lord, ultimately, my lord, they are living separately for the last, my lord, about 5 decades, my lord. But regarding permanent alimony, my lord, to be very candid, I had an issue. My lord, he is earning a salary more than 1 lakh, and the alimony permanent alimony granted 5 lakhs. And my lord, when I moved the appeal, my lord, this point I took this point that how the suit has been decreed, and in the affidavit of assets, my lord, the other honorable division bench, my lord, took an exception. My lord, he said that take home salary is 85,000 and his expenditure is more than lakh, and he was grieved. Not kindly seize the order 4/4/2024. Your lordship will get the, my lord, picture. He is an employee, my lord, attached with the Chandanagar Police Commissionerate.
You are unemployed. Okay.
Yes, yes.
You can place it, Mr. Right?
My lord.
Read it out.
The order.
The order. We'll look through the order.
Page 102. It is persistently contended by the counsel for the respondent that the impugned judgment and decree is passed on consent, but we do not find from the tenet of the said order that it may be construed in such a manner. The trial court has wrongly shifted the onus on the wife appellant to disprove the cruelty as alleged against her by the husband respondent, but ultimately the operative portion of the said judgment and decree would reveal that the decree was passed on contest. Even if something has not been denied or has been impliedly accepted, it does not ipso facto lead to a conclusion that the ultimate decision taken by the court is on consent. It is a proceeding under section 13(1)(a) of the Hindu Marriage Act alleging the cruelty as well as desertion against the wife appellant, and such proceeding in our view cannot be decreed on consent as there is a separate provision incorporated in the said statute, that is section 13(b) thereof, providing the mechanism where the parties can seek a divorce on mutual consent. We therefore, unable to accept the contention of the impugned judgment is passed on consent. We are faced with the aforesaid 2 applications taken out by the respective parties. Can 1 of 2023 is filed by the wife appellant claiming maintenance alimony pendentality at the rate of rupees 25,000 per month, and Can 2 of 2023 is filed by the husband respondent for appointment of the special officer for undertaking an inquiry.
Inquiry regarding what?
About the assets. Taking the application filed by the husband respondent first, it is not in dispute that pursuant to the order passed by this court directing the parties to file the affidavit of assets and liabilities strictly in terms of the judgment rendered by the Supreme Court in Rajneesh versus Neha, such affidavits are filed by the respective parties. The application taken out by the husband respondent contained several allegations relating to suppression of annual income by the wife appellant, as she received considerable amount of money from various deposits, rent from the parental property, and the income derived from private tuition. Not a single iota of piece of paper is produced so far as the rental income and the income from private tuition are concerned. The reliance appears to have been placed upon an application taken out under RTI Act before the competent officer of the Bharat Sanchar Nigam Limited, which on meticulous reading thereof does not sufficiently reveal any income on the account of rent derived by the wife appellant. The said letter is routed to the wife appellant to furnish the information as sought by the husband respondent, and therefore it cannot be said to be a document of sanctity touching upon the rental income of the wife appellant. Furthermore, if the Bharat Sanchar Nigam Limited was paying a rent to its landlord, we do not find any justification on the part of the said authority in not disclosing the quantum of rent. The moment the information is sought for is not within the knowledge of the said authority, as it appears that the said information was restricted to the wife appellant. We do not feel that solely on such score the court can arrive at a conclusive opinion that there has been a suppression by the wife appellant. So far as the fixed deposit is concerned,
Their allegation was that you are the landlady of Bharat Sanchar.
no, my mother is the landlady. And that too, my lord, the BSNL was there, my lord, decades back. I took that part. So far as the fixed deposit is concerned, a copy of the special term deposit receipt is annexed to the affidavit filed by the respondent. It appears that a sum of rupees 10,000 was deposited into such fixed deposit on 25th February. It should be 2003. It is a misprint. For a period of 36 months and stands in the joint name of the appellant as well as her mother. The date of the deposit would reveal that the parties were living together in a matrimonial home, and therefore an affidavit filed in 2023 showing that there was a fixed deposit in 2003. That's why, my lord, I said that it is a misprint, which was due to mature in 2006. Cannot be of any relevance nor can be perceived as a suppression. The wife appellant has disclosed that she has no income of her own and is dependent upon her mother. In course of hearing, it is submitted that there are other co-sharers, and in fact the mother is residing therein and the wife appellant is dependent upon her in all respect. It is also undeniable that a paltry sum of rupees 7,000 per month is paid as maintenance in other proceedings, and the same has been discontinued since the month of September 2022. We thus do not find any material far to speak of any allegation warranting the appointment of the special officer to make an investigation into the affairs of the wife appellant relating to her income. Astonishingly, we find from the affidavit filed by the husband respondent that he has disclosed his net monthly salary of rupees 80,506. He has also disclosed a sum of rupees 1,000 from agricultural land without disclosing whether the said sum of rupees 1,000 per month or per year. Even if we consider the same to be monthly income, the total net income of the husband respondent is 81,506. Interestingly, he has shown several personal loans charged with the salary account of the husband respondent, which are also paid through NEFT. Taking into account the disclosure, the actual income and banking upon the stand that the moment permanent payment of maintenance to the alimony is granted, no further payment of monthly alimony is warranted. We hold that once the portion of the judgment awarding permanent alimony is paid, the respondent can escape from his liability to pay the monthly maintenance. We have been given to understand that since the month of October 2022, the husband respondent has stopped paying the said sum of rupees 7,000 per month, and the wife appellant is in dire need of money as she has an apprehension of being deprived of a roof over her head at any point of time. We therefore direct the respondent husband to pay the arreared maintenance at the rate of 7,000 on and from the month of October 2022 till the month of March 2024. Within 2 months from date, this has not been paid. On and from the month of April 2024, the husband respondent shall pay a sum of rupees 20,000 per month as alimony pendentolite within 7th day of each month, following the manner as the said amount of rupees 7,000 was paid to the wife appellant. 3 months have been paid. May, June, July. At this stage, the counsel for the husband respondent submits that the wife appellant is not taking any steps to get the appeal ready for its disposal. Even the paper books have not been filed. Our attention is drawn to the records wherefrom it appears that the trial court record is received by this court on 21st June 2023. After the examination of the record, the department has notified that several exhibits have not been included in the trial court record. As those exhibits were received back by the husband the court below on 22nd December 2022 with an undertaking to refile the same as and when called for. Since the trial court record is not complete, naturally the question of filing paper books does not arise at this
Now the
stage.
trial court records are complete.
Yes, yes,
because you have
because I
prepared
filed
the
paper
paper.
books. The husband, they were keeping it withheld by supplying.
But
The-
they have refiled all.
Yes, yes, that is over. The husband respondent is directed to refile the exhibits taken back from the trial court within a week from date. After filing of the aforesaid exhibits, the office shall re-examine the trial court record and it found complete this and that. The appellant is directed to file informal paper books. This part is also over. Since the appeal, page 108.
10,000 litigation costs also not paid.
Yes, paid.
That has been paid.
Litigation cost because for filing paper book, the court ordered
Oh,
that
he paid the litigation cost, but is not paying the alimony.
No.
Nothing has been paid out of this arrears also.
No, nothing.
But he has paid the litigation cost for
Yes.
expediting the appeal.
Yes. Because this was, my lord, the court's observation was that how
Yes,
can she
yes,
file a
obvious,
paper book? How can she file a paper book unless, my lord?
Have you quantified what is the due till date?
So till date, my lord, in my application, my lord, I have because this has been filed, my lord, in July. My lord, I was mentioning the matter, my lord. I have
you quantified?
Exact figure I did not quantify.
Oh, very well. Let us
But I have-
calculate. 7,000 from.
I have quantified.
You have quantified.
My lord, that is 1,26,000 because that was, my lord, till October. Yes, yes. That is the idiot is I have quantified.
7,000.
Total how much?
1,26,000.
No, October 2022 till March 2024.
2,72,000. Check it.
Mr. Rai.
For the 7,000, the earlier one.
Mr. Rai, October 2022 till March 2024, what is the quantum? Rupees 7,000?
11 lakh.
Yes, that was
11 lakh.
no 7,000.
1 lakh 12.
26,000. 26,000 according to me, if I'm not wrong, my lord.
Take out your phone and calculate.
No, my lord, I have done it.
7,000.
It
Into
should
how
be
many
from
months?
October 2022 till the March till the
Sir.
month of March 2024.
Listen to me.
Lordship.
October 22, October, November, December, 3 months.
3 months.
Thereafter 23, 12 months.
12 months.
15 months. And in the next year, 3 months.
3 months.
How much comes?
18 months.
18 months.
18 into
So,
7.
18 into 7. How much it comes?
Well, it comes to, my lord, 1,26,000.
How much has it come?
1,26,000. Yes, that is what I have. I have made it. And
1,26,000.
yes.
And
thereafter, my lord, he is supposed to pay, my lord,
1,60,000.
Lordship.
No. April to November. April, May, June, July, August.
December.
No, he has paid. This 20,000 paid for 3 months.
Oh,
up to?
Up to means, my lord, May, June, July, August. As per May, June, July, as per my
Then
instruction.
from August till date, he has not.
No.
It should be April, May, June. 3 months.
April, my lord, according to the bank statement, my lord, what I got the instruction, he did not pay for the April. From May onwards, he paid.
May onwards means for the month of April on.
Anyway, we are now in
April, May, June.
we are now in the month of December.
December.
So forget about December.
Lordship.
April to November.
Lordship.
April, May, June, July, August, September, October, November. 8 months.
No.
-3.
-3. 5.
হ্যাঁ এপ্রিল
তারপরে 1 লাখ।
এপ্রিল মে জুনেরটা দিয়েছে জুন পর্যন্ত দিয়েছে জুন তারপর আর
জুলাই আগস্ট সেপ্টেম্বর অক্টোবর নভেম্বর
7 মাস
5 মাস
5 মাস
হচ্ছে 20,000 টাকা করে হচ্ছে 1 লাখ
so 1 lakh
আর 1,26,000
2,26,000
2,26,000
till date.
that is it
the figure it's coming as on date.
Where he is working?
Well, at Chandanagar Police Commissionerate, but in the department of IB. Well, if your lordship takes the impugned judgment, your lordship will also find. Well, at page 73. Page 73. Well, it is the middle, second paragraph, third paragraph. From the examination of PW1, it will appear that the said side of OP only harped and hammered on the point of financial aspects. He deposed in cross-examination that he is assistant in charge.
My lord, I am for the respondent. I'm sorry, my lord, I was in another court.
So nice to have you here after the hearing is over. What were you doing till now? We have heard the matter. We are going to attach your salary. Why are you not paying?
My lord, already, my lord, kindly let me say, my lord, I was totally paralyzed because of the heart attack and all those things. That's why I could not give. Today I am paying this, whatever I have not paid, that
That's
1,26,000.
Plus?
And up to August, I have, my lord, I have already paid up to August. And I was.
How much you have paid, sir, after passing of the order?
Yes, my lord.
How much you have paid after passing of the order?
After passing of the order,
Coordinate me.
80,000. 80,000 already I have paid from April. I have paid April, May.
4 months.
4 months I have paid, and rest I am paying today. Today I have got that check.
Fair enough.
Which was that previous one from October 22 to March 23, 24. 24. That I have already, that check also 1,26,000 is coming.
Very good.
And rest of this months after August, September, October, November. There are 3 months I am paying today. Today only I will hand over the
August up to now. You said April, May, June, July. You have paid.
August up to 31st August I have paid.
There is a confusion with regard to 1 month only. I shall clarify that.
And that amount today I'll pay the check. Already my clerk has.
We'll keep the matter on Monday.
Yes,
Ascertain
my lord.
whether they have paid. Well, fair enough.
And my lord, kindly allow me to give me written submission, my lord.
Let the appeal be heard out, my lord, as per your.
No, you want to file an opposition to this attachment application?
Not can, my lord. That total written submission about the.
We'll hear the appeal on merits.
Yes.
Yes, my lord.
We'll hear the appeal. We'll hear your oral arguments. If necessary, we'll take your written notes of argument.
Yes, my lord.
Right.
Today only this can.
Today only this can.
Yes, my lord. That already I have.
Can we are not disposing of. We'll keep the can on Monday to ascertain whether you have paid all the,
Yes, my
the
lord.
entire amount. And if you are satisfied on that, then immediately within 1 or 2 days we'll keep the appeal for hearing.
Yes, my lord. Deeply obliged, my lord.
Your check is ready.
Yes.
Is a banker's check.
Yes. No, banker's check. Banker's check. Demand draft. Equivalent banker's check.
সোমবার রাখবো তো ব্যাংকার্স চেক হোক
Yes, my lord. I'm giving the assurance. I will myself.
From the submission of the learned counsel appearing on behalf of the appellant, we find that the calculation comes to 2,26,000. Please sit together.
Yes, yes.
whether
But
it
there is a
right or
confusion
not.
with regard to 1 month. I shall ascertain that.
And
You
my
have to
lord.
clear all the dues.
Yes, my lord. That in the main petition, main appeal.
না না আমরা টাকাটা দিতে বলবো তো আজকে সাবমিশনটা রেকর্ড করতে আচ্ছা আমি বলে দিচ্ছি The present application bearing can 3 of 2024 has been filed for appropriate order seeking attachment of the salary of the respondent husband for non-payment of the alimony as directed by this court with a order dated, what was the date of the
4/4/2024.
April 4, 2024. Push up next para. Learned counsel appearing for the respondent husband appears and submits that due to the respondent having suffered from paralysis in the meantime, comma, the payments could not be cleared, full stop. However, comma, the husband is prepared to pay the entire amount of arrears by way of banker's check stroke demand draft by today. Full stop next para. Accordingly, in view of such stand taken by the respondent husband, comma, we direct the respondent to pay the entire arrears by way of demand draft stroke banker's check to the appellant wife through her learned advocate on record in this court by tomorrow. Full stop. The না বাই চান্স যদি আজকে না দিতে পারে আবার তার জন্য এক্সটেনশন চেক বাই টুমরো দিচ্ছি দিয়ে দেব paid today we are giving you to tomorrow for abundant caution by tomorrow full stop the application along with the appeal shall be listed next on December 16 2024
Deeply obliged.
একটা দিন এক্সট্রা না দিয়ে রাখলে বাই চান্স যদি কোনো কারণে তারপর দেখা গেল ফ্যাকড়া আছে কোনো চেকে তখন আবার Please file to be kept on record.
এইটা রয়ে গেল
চেঞ্জ করে দেয়ার উইল as to but wait
আচ্ছা
এটা
তাহলে একটা কেটে
লিখলেই হতো এই শেষের দিকে নাম্বারগুলো চেঞ্জ হয়ে যাবে তাহলে এই পাতাটা একটা চেঞ্জ করে দিতে হবে চেঞ্জ করে নিয়ে আসো তারপরে আমি কোনটা কাটবো এইটা কাটবো না এইটা কাটবো যেহেতু ইন্টারিম অর্ডারটা এখানে দিয়ে শেষের গুলো লিখতে
না ক্যানটা জিততে সুপার এটা এটা কেটে
এটা দিয়ে আমি ওটা কেটে ইনিশিয়াল করে
তাও করেন
যদি বলেন টেস্ট করে
না শেষ করে আপনি হচ্ছে দুজনেই আছে আজকে তো এটা ফেলছি ওইগুলো আপনি কেটে দেন রেকর্ডটা ক্লিয়ার আছে
Item number 30. Lord, item number 30, I beg to appeal for the appellant. My
Yes, Mr. Shamul.
The executor of a will is the appellant before your lordship. An
Is
application.
the delegate dismissed?
Delegate dismissed. Your lordship.
That's why
Your lordship,
quadruple X in the contract.
your lordship kindly sees the order passed by this honorable court dated
not prove the
16th.
will.
My lord, that is not the consideration. Your lordship, I will place a short judgment. It's only of five, 6 lines. Probably the district delegate is not aware of what is his function and how your lordship kindly sees the order passed by this honorable court dated 16th October. We have preferred an application so that the appeal could be taken out for hearing, and their lordships of the opinion that no records are called for.
Yes, yes, we are taking up the appeal for you.
Your lordship, testatrix executed a will on 20.
What about citation?
Lord, that is, I tell you, your lordship.
There is no other heir.
No. The two of the heirs, the class 2 heirs, they have given their consent, and one of the consent have deposed also, and he has been classified as an opposite party witness. Your lordship.
Let us see.
The one Mukulika Mitra, who is a testatrix, executed a will which is duly registered. The date of execution of the will is 16th March 2016. In the will, she have appointed the executor, appellant before your lordship, the sole executor.
You are the beneficiary as well as
No. She is not the beneficiary. She is one of his nephew, and another niece was the actual beneficiary. She was spinster. She died as a spinster, and having no class 1 years, class 2 years, she died. She died leaving behind one brother and one sister. After her death, an application for probate was filed. Both the brother and sisters, they have came up with a.
Mr. Shamul, better read the impugned order.
My lord.
That narrates everything.
My lord.
So let us
Your
just
lordship,
go to that.
the order dated dated 5th of May.
Yes.
Today is fixed for final order in respect of petition filed under section 276 of Indian Succession Act, dated 14th June 2021. The case of the petitioner in brief is that he has filed this case for granting of probate of the last will and testament of deceased Mukulika Mitra, daughter of late Shoilendra Kumar Mitra, resident of 201 Subuddhipur, Middle Road, such and such, leaving behind Tripti Sarkar and Pradip Mitra, alias Pradip Kumar Mitra, as her legal heirs. Mukulika Mitra, during her lifetime, had executed her last will and testament on 16th March 2016 and bequeathed his property to her nephew, Orko Mitra, and appointed the petitioner,
Only
Shoibal.
because you did not cite the nephew who is the
Right.
beneficiary, for that it has been dismissed.
And also, my lord, the district delegate went on interpreting the contents of the will. Your lordship kindly sees the judgment.
Can you let us continue?
My lord, as a legal. Yes. Mukulika Mitra, during her lifetime, had executed her last will and testament on 16th March 2016 and bequeathed his property to her nephew Orko Mitra and appointed the petitioner Shoibal Sarkar as executor to take probate of her last will and testament. Under these circumstances, the petitioner is praying for granting of probate.
This was a spinster.
She died was as a spinster.
This was a spinster.
Opposite party, namely Tripti Sarkar and Pradip Mitra, alias Pradip Kumar Mitra, appeared and given consent to the petition of the petitioner. Following witnesses have been examined. PW1 Shoibal Sarkar is the appellant before your lordship. The executor, and PW2 Debashish Rai Chaudhary is one of the attesting witness. And the following witness have been examined on behalf of the OP. There is no OP. OPW1 Pradip Mitra, Pradip Kumar Mitra, he is one of the consentee. And following certain documents were exhibited, original Aadhaar, death certificate, will exhibited. And following documents have been marked as exhibits on behalf of OP.
Death certificate has been exhibited.
Yes, my lord. Death certificate has been exhibited. Exhibit 2. Your lordship kindly sees exhibit 2.
Yes, I got it.
And the
Aadhaar
will
card, death
exhibit
certificate, everything.
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 Hard learned advocate for the petitioner on
Passport,
last
right.
occasion perused the application, evidences and other materials on record. After perusing exhibit 4.
What about this OP having exhibited?
My lord, that is OP is the my lord
IT, that's the
consenting.
Consenting parties have,
Consenting, one of the
in order to prove their identity, they have
tender this Aadhaar card. And after perusing exhibit 4, which is the registered will and testament of the deceased Mukulika Mitro, it appears from the page of the said will that she bequeathed absolutely and forever his nephew Orko Mitro, son of Pradeep Mitro, aged such and such, for his use and benefits of the property mode described in the schedule of the plaintiff, written including all assets and credits and whatever character or whosoever situated, including as reversion expectancy of future assets, if any, acquired by out of the property and or demise, it would vest absolutely on a said nephew, with full authority, liberty to dispose of my property, be left by her at his own will, desire, discretion, power to alienate self. Furthermore, page 6 of the instant will, which is the schedule of the property and being the subject matter of will, reads as follow. He went on describing the schedule of the suit.
Very
good. Compare such and such Mauja. And there is no mention of movable properties. Now, from the application under section 276 of Indian Succession Act as filed by the applicant, executor Shoibal Sarkar, it appears that the application has been filed without citing the party which ought to have cited. Here the beneficiary, that is Orko Mitro, who is also her legal heirs, being the nephew, had not been made party, nor notices were issued upon him, nor whose benefits the property has been bequeathed. After probate application is submitted, notices must be issued to the legal heirs of the deceased about the fact of application, and a general notice must also be published, giving an opportunity for raising objection to the grant of probate. Here, though the petitioner mentioned 2 legal heirs of the deceased testatrix, but his nephew is also a legal heir, rather beneficiary, and no cogent documents have been filed to establish that deceased Mukulika Mitro had only 2 legal heirs. He is not a legal heir because brothers, your lordship knows.
I hope you will not make any argument that notice of appeal be issued to the court below.
Moreover, from the schedule of the instant petition,
Orko Mitro was not the heir also. He was a
he was nephew.
And as well as the beneficiary.
He is the beneficiary.
Beneficiary, forget that. I mean, even forgetting that. I mean, otherwise also.
Because probably the district delegate have misconstrued the succession, because
the hierarchy of succession.
Hierarchy, because class 2, they both of them were cited and they gave their consent.
Yes.
And most interestingly, hereafter, moreover, from the schedule of the instant petition, it further appears that part 1 consists of immovable assets left by the deceased and part 2 includes movable assets left by the deceased. But from the schedule of the will specifically mentioned in page 6 and as discussed before, the term any property acquired by me or in my name subsequently must be interpreted as ejus dem generis. That is of the same kind which should be immovable property. The will never speaks of any movable property. A probate is a method through which a will is certified under the seal of court, and a probate establishes the authenticities of the will finally. So a probate cannot be granted beyond the terms of the will, subject to any codicil, which is also missing in this case. In the light of the above discussion, it is now crystal clear that not only the cited party had not been added in the petition, but the prayer for probate had been made beyond the terms and conditions of the will. In these circumstances, the prayer for grant of probate cannot be considered.
Will property ঢুকিয়েছি তার কারণ হচ্ছে any other property acquired by me in the meantime সেটা ঢুকিয়েছি কিছু গ্রাউন্ডে হতেই পারে
To look into the contents of the will. And for your lordship's section, I have also brought the.
Yes, we were wanting to see that. It was court of conscience after all.
My lord.
The will in question.
Will in question.
Will not in question, actually.
I found section 63, my lord, everything, all the requisite.
Section 63 has been there because the attesting witness
my lord, that
attest evidence. What else remains? We hope that she has not gone into that also.
No.
Have you got a copy of the deposition also?
Yes, my lord.
Just we want to be satisfied that 663 criteria signed before him, signed before all those things. We
The
want to
entire evidence, my lord, even my lord, the consentee evidence whom the learned district delegate in the court below have referred to as the opposite party. That is also my lord, the entire evidence.
What about Schedule 2 and Schedule 1? Let us see that also once. Where is Schedule 1 and Schedule 2? Court speaks about Schedule 1 and Schedule 2.
So there's only one schedule.
Yes. Where is Schedule 1 and Schedule 2?
That is in all in
The application.
submission, the application affidavit of asset.
Probate application do you have?
Here, my lord, that is my lord, part of
Here, part of this.
my application, my lord.
All right.
Application for appropriate order.
Part of the second one?
Yes, my lord. Page.
Yes.
The application at page 12. Schedule A above referred to part 1 immovable assets left by the deceased, and on the next page at page 13.
We don't. This is not paginated.
And the application for my lord, the application which to dispose. The application was annexed with the application can 1.
Oh, where is the can? Where is that can?
Can 1 at page 12.
Yes, got it.
Your lordship sees this is my Schedule A, description of the movable, immovable assets left by the deceased, and on the next page at page 13, part 2, movable assets left by the deceased, and thereafter Schedule B, which by law is entitled to.
There is part 2 is covered by the last paragraph of page number 4 of your brief.
Yes.
My lord. My lord.
Challenge in this appeal is the order number 15 dated 5/5/2022 as passed by Learned District Delegate Baruipur in this case probate 15 of 2021, whereby and whereunder the said court rejected the appellant / petitioner's application under section 276 of the Indian Succession Act 1925, hereinafter referred to as the Said Act, for grant of probate to the last will and testament of the deceased Mukulika Mitra. Stop that. We have heard learned advocate for the appellant. Stop. We have also perused the order which is impugned before us. On perusal of the entire materials as placed before us, it reveals that the appellant, being the executor to the last will and testament of the deceased Mukulika Mitra, approached the court of the said court of District Delegate Baruipur with a prayer for grant of probate by filing an application under section 276 of the said Act. Stop. It appears that after completion of the formalities of service of notice of citation upon the interested parties having caveatable interest. The said case was taken up for final hearing when the present appellant, being the executor to the said will and testament, tendered himself as PW1, and in course of his examination in chief, he duly proved the death certificate of the deceased and adduced evidence that the deceased, that is the testatrix, prior to her death, executed her last will and testament, for which probate has been sought for. It further appears to us that one of the attesting witnesses, namely Devashish Raichaudhuri, also deposed as PW2, and in course of his examination in chief, he duly proved the will in question, comma, the signature of the testatrix, and the signatures of the attesting witnesses, including himself. Signatures of the attesting witness, including the signature himself, including the signature as put by him in the said will as an attesting witness. Stop. It appears to us that the learned district delegate, while passing the impugn order, duly appreciated the evidence as adduced by the PW1 and PW2, and also noted that the consenting parties, namely Tripti Sarkar and Pradeep Mitra, alias Pradin Kumar Mitra, who had received the notice of citation, had given their due consent to the grant of the probate as prayed for. Learned trial court, however, in the impugned order, found that notice of citation was not served upon the beneficiary of the will, which ought to have been done according to the learned said trial court. And learned district delegate came to a finding that that is an incurable fault which cannot be rectified. In his latter portion of the order, the learned district delegate also came to a finding that the part 2 of the schedule of the application for probate deals with the movable assets left by the deceased, which, however, found no place in the will in question. Stop. In course of his submission, learned advocate for the appellant submits before this court that while passing the impugn order, learned district delegate has failed to visualize the true spirit of the said act. It is contended that it is the duty of the district delegate to ensure that notice of citation has been served upon the legal heirs, and there is no requirement to serve notice of citation upon the beneficiary, especially when the named executor to the will is seeking probate basically for the benefit of the beneficiary. Learned advocate for appearing on behalf of the appellant further submits that learned district delegate ought not to have gone into the wordings of the will in absence of any doubt with regard to the execution of the will. Stop. We have meticulously gone through after careful consideration of the entire matters as placed before us. We noticed that after filing of the aforementioned case for probate, notice of citation has already been served upon the near relations, and on receipt of the same, they have given their due consent, which has been recorded by the learned judge. We find further that the will in question has been duly proved by one of the attested witnesses. Stop. No case has been made out from any corner that the execution of the will has been done in such a manner which raises a shadow of doubt with regard to the genuineness of the will in question, or with regard to the competency of the testatrix, both physical and mental, at the time of the execution of the will in question. Stop. We find within the four corners of the said act, we find no provision for giving notice of citation of a will, notice of citation of grant of probate upon a beneficiary, which in our considered view, learned trial court has failed to has misconstrued and has failed to visualize in its proper perspective. Stop. In our further considered view, when the execution of the appeal is not under challenge by anybody,
Execution of the will.
execution of the will is not challenged by anybody, and especially when no materials have been placed before the district delegate regarding any shadow of doubt with regard to the execution of the will and with regard to the competency of the testatrix at the time of the execution will, learned district delegate has committed serious error of law and in fact in not allowing the application for succession certificate. Stop. It will be so far as the discussion is made in the improved order regarding the movable property. So far as the finding of the learned trial court regarding the alleged absence of the movable property as disclosed in the schedule 2 of the application for probate, in the will in question, we find that the reason assigned by the learned district delegate is faulty in view of the fact that in the last paragraph of page number 4, it has been expressed by the districts that even after execution of the will, if she acquires any property
Future asset.
and oblique or future asset, that would come under the purview of the will, and the the same would devolve also upon the beneficiary of the will, for which probate has been sought for. Stop. We thus find no reason for rejecting the prayer for grant of probate. So accordingly, the instant appeal is allowed. Consequently, the order number 15 dated 5/5/2022 as passed in this case probate number 15 of 2021 by the district delegate Baripur is hereby set aside. Consequently, the application under section 276 Indian Succession Act 1925 as filed by the present appellant before the district delegate in this case probate number 15 of 2021 stands hereby allowed. Stop. District delegate Barupur is hereby directed to grant probate to the present appellant / petitioner on furnishing requisite amount of court fees.
Can one of 2022 get accordingly disposed of as well?
With the disposal of the instant appeal, can one of 2023 is also disposed of.
আচ্ছা আরেকটা জিনিস এখানে যেখানে অর্ডার বলেছে
I'll not take 1 minute, Lord. I'm being led by Mr. Bordho. We have already intimated it last day. He's not available today. I'm requesting Lordship to fix any date next week or this week, tomorrow. I have no problem. Only seeking adjournment for the day.
After vacation, I only fixed it after vacation.
Why?
I have deadline, Dr. Vasu requested.
an adjournment is sought 31 দেখান বোর্ডে
Yes.
An adjournment is sought you are for the respondent. An adjournment is sought by the appellant who learned counsel for the respondents submits that the matter be taken up after the upcoming Christmas winter vacation within bracket Christmas vacation of this court. Who accordingly let the matter stand adjourned and be listed under the same heading in the monthly list of January 2025. Paper books filed in court today on behalf of the appellant be kept on record. Yes, sir.
May it please your lordship. My lord, hierarchy, my lord, I'm not even getting into that. My learned senior friend wants to say, my lord, if I've heard him correctly, is that he has obtained a degree. His degree is being registered. So, my lord, I have to pay money, my lord, so that he is compensated. Now, this comes, my lord, from the backdrop of Atmaram. Atmaram said that the landlord, if he has obtained a degree, the tenant or the degree or somebody who is a judgment debtor will have to pay the money which the landlord would have got if he had, my lord, rented out the money on that particular day of the degree. This is the, my lord, your lordship knows it well. That's the last paragraph of Atmaram. I've called for it. I'll show it to you. Is that he is entitled to the money which he would have got if he had let out the money on that particular day, my lord, when he obtains the degree. So first of all, his right to let out comes in here. On that, your lordship has seen the facts. The facts are.
In other words, the usufruct, he must not be
Deprived of his
usufruct
of that degree.
That is the exact wording. So far, I
My
buy the
lord.
collection.
I'll show you, lordship. That's the last paragraph. That's the only part which is relevant today, my lord. Is that he should get the money which he would have got the money if, my lord, the tenant was not in occupation. And that's why, my lord, whatever be the rent earlier, you had to pay the current market prices. Here is a case, my lord, where the landlord is law, no dispute. The lessee is international club, no dispute. Lessee inducts my learned senior friend's client, Jenny Christensen, no dispute. He is saying today, my lord, that I am a licensee under him. Am I, my lord, if I'm kindly corrects me, my lord, may I ask this question to myself. So if he has inducted me, then he can't get a degree against somebody else and say that you pay occupational charge to me. His argument would have been correct if he had filed a suit against me and obtained a degree.
No, he's not recognizing you.
He is. He's saying
Not
that.
recognizing you. He is recognizing a person against whom he has obtained a degree which has been affirmed in
So
the first
that
appeal and the second appeal.
So that person, my lord, is liable to pay him if he at all gets, my lord, whatever he gets.
Now you approach
I am
filing an application under Order 21 Noon 9799, read with 101 of the Code of Civil Procedure, claiming your independent right, title, and interest, which you failed.
Yes.
So his submission is that for all practical purposes, because of your intervention, neither he can execute the degree and nor he can get the benefits of the degree. Why the proposition of law as enunciated in the case of Atmaram would not be applicable in this case?
I bow.
So far, I have understood.
Bow down, my lord. So your lordship is on a case where there is a degree against a tenant. Landlord, tenant, there is a degree, inter se, and that degree is sought to be executed. No, my lord, it's all. It will be both sides, both ways. So, my lord, he is not my landlord today. He doesn't have a degree against me. He has a degree against some Zahil, who he says, my lord, who he recognizes that he is the person who is to give him back possession. So my title, my lord, or my right vis-a-vis this property is yet to be decided, my lord, finally before your lordship. I am resisting on the ground that at the teeth of a degree against Zahil, who is an absolutely fictitious person, you are trying to evict me. If you are saying that he's recognizing me, Lord, it fell from my lord yesterday, my lord, that the landlord is in that letter, my lord, which we are relying upon, that the induction is by Jenny. That it's written there that the induction is by Jenny. If there is an induction by Jenny, my lord, then he needs to file a suit against me to obtain a degree, not against somebody else who is a Zahil. To retort my learned senior friend's submission, my lord, kindly looks to what he is relying upon. Have a look at the plane, which your lordship will find is the first annexure.
It should be
in the opposition. At page 59. he is relying upon.
This is a different suit. filed by my lord,
Absolutely.
Yes.
And there, my lord, he is saying that both Mohan Singh and my lord George Zahid, my lord, is father's name not known, both on residing on the first floor at premises. So he now knows that I am residing there. And this, kindly have a look at the schedule of the premises. I'm good. Have a look at the schedule of the premises.
Prior to that, kindly read paragraph 2, of which our notices has been drawn by your other side.
My lord, at all material times, the defend numbers 1 and 2 were on and are still residents in the apartment. So my possession is admitted.
You are Mohan Singh.
Huh.
And so far the Zahil is concerned, his poison is admitted.
Well, that's Mihil law.
Please read out then.
Miller, I am not on that.
No, read out the entire portion.
Situated in the first floor in the main building of the said premises, public such and such are occupying the same as licensees under Jenny Christensen.
So
very well. So I am in possession.
If you are to place reliance upon this paragraph, you have to rely it on the whole.
Miller, I'm probably not
cannot
making
take
myself
the
clear.
one and the remit.
Miller, I'm not probably making myself clear.
Yes.
What is happening here? There is no degree against me. Kindly appreciates that. There is no degree against me. If there was a degree against me, then below this occupation charges of paying him comes into play. Today, my lord, his right vis-a-vis the property is gone. Kindly appreciates that. What I am trying to tell your lordship is, he knows I am in possession. That's what he claims. He knows I am in possession, but there is no degree against me. Atmaram comes in when there is, my lord, a degree against me of eviction. He knows that I am in possession, as I take it for granted, my lord, because he is relying upon me. He has not filed a suit against me and obtained a degree. He has filed a suit against Zahil, not even George Zahil, my lord, if I'm not, my lord, his father's name is not known. Now, this was a suit, a schedule of which, my lord, is of a garage and marks it, my lord, the date of that suit. Very important. The date of the suit is 76. If I'm not mistaken, my lord, 76. And the entire scenario changes, kindly comes back to, my lord, my stay application. Comes back to them. What I'm trying to tell your lordship is that they can't play around, my lord, with court. You find out somebody and say that this person is there, obtain an ex parte degree against him and throw me out of the property, when you yourself are saying, relying on a document which is saying that I am in possession. And they are saying, my lord, that I am a licensee under him. He is trying to rely on saying, my lord, that I am a licensee under Jenny. That's him. So if you want to say that, then it's before the court of law that you ought to have filed a suit against me and obtained, my lord, a degree. You know very well that I am in possession of that premises, but you can't have a right against me vis-a-vis the property. My lord, my right is not vis-a-vis him. My right is vis-a-vis the property. He needs to establish his right first. Today, my lord, I file a suit for eviction, my lord, of Taj Mahal, and I obtain a degree. The Waqf, my lord, who is in possession there, but who is the owner of the property, my lord, somebody else is, my lord, being evicted, my lord, by way of that degree. May I ask this question to myself, whether this is tenable? My lord, International Club was the lessee.
Mr. Chatterjee, under Section 16, can a licensee invoke Section 16?
My lord, I'm not even invoking Section 16.
Your
Lord,
basis of claim is that you have become a direct subtenant under him.
I have become a tenant under him.
Direct tenant under the landlord.
Under the landlord. I am not in, my lord, what happens is, International Club has surrendered its tenancy. With his surrender, my lord, his right goes.
No, if you are, because the landlord says you are claiming to be a direct tenant under the landlord.
Yes, sir.
Now that landlord himself says that he was the tenant and you are a licensee under him.
He was not a tenant. He was a subtenant.
And you are a
And
licensee
I am
under
a
him.
licensee under that.
Under that
That is
subtenant.
76.
That subtenancy is recognized by the landlord
That
and
is
approved.
76.
Yes.
Yeah.
But
Then,
you are a
what happened?
licensee.
In 87
Can a
scenario-
licensee invoke section 16?
I am not invoking 16. 16 is when a
Unless you
subtenant
show that they have been evicted or they have surrendered.
I bow
they
down.
went-
Surrender.
Gone out.
International club surrenders the tenancy. Admitted fact.
Admitted.
Admitted fact. Admitted facts. International club surrenders tenancy. On the surrender of international, I'll show you the letter right away. On the surrender of international club, the subtenant goes. That's genuine question, sir. His rights vis-a-vis the property goes. His rights vis-a-vis to evict me from the property goes. So he today, my lord, cannot let out the property today, my lord, to somebody else if, my lord, that degree is executed.
But you have been described as a licensee under him.
In a 76 situation, in an 87 situation, entire thing has been changed. My lord, I've been described as a licensee.
Superseded as a licensee remains unless, I mean, superseded by that.
Take it for instance, my lord, my right as a licensee remains. My licensee under him remains, not licensee under the landlord. I am not fighting the owner of the property. My right vis-a-vis the property remains. When the landlord has given me that right, he is nobody anymore. His right to take rent from me, my lord, is taken away. Because he is claiming a right, my lord, under the subtenant. Kindly appreciate, under the tenant. Once the tenant goes, the subtenant's right go with him. My lord, if a situation, Mihir law files a suit against international.
Take advantage of that.
I am not taking advantage. I am resisting. There is no degree against me. I am not taking advantage. Kindly appreciates that.
Then what
He
would,
is taking advantage.
then what would be the implication of Order 21 Rule 103?
That's
It is a deemed degree.
It's a degree.
You
That's
failed
why
to-
I'm before your
you
lordship.
failed to establish your title.
My lord, Order 21 Rule 103 failed to establish a title. My lord, the court has held. I have given documents, but I have not given the entire documents from one point to the other.
What is the ultimate result, sir?
The ultimate result is, my lord, it's completely malafide. If your lordship feels that he has a right to obtain money from me, I understand.
Mr. Chatterjee, can we have a look at the decree?
Certainly. I don't have that.
Degree.
I don't have that.
Memo টা দেখতে হবে।
The degree that he's obtained, my lord.
Yes.
Yes. No. No.
In the memo, it should be there. Yes.
My lord, degree of the he's obtained against Jahil.
Yes.
Yes.
It has been annexed.
Yes. Yes.
No, that has, unless that is annexed, we won't get it because that is not the impugned degree here.
My lord, 56 of the opposition. Have a look at below the second paragraph, second page at 57. It's a judgment. Degree does. Taken up for expert. Look, lordship is going through. And then kindly sees the finding is that he's left the property suit trial more than 6 months before filing of the suit. At second page. My lord, kindly call it.
An ex parte order.
Yes, my lord. Ex parte degree. And then, yes, and then sees the plaintiff has claimed mean profits of 300 per day, but since the lodging charge for the flat 950 per month, the plaintiff will be entitled to damages at that. So, I'm sorry.
Yes.
Do you file? I'm sorry.
Yes.
So you file a suit against somebody who's no longer there, brings up a document for the first time before the appellate court and say, look here, there is a suit in 1976 where the landlord has admitted Zahil to be there. Your case is that Zahil has left the property 6 months back. More than 6 months back. That's his case, Milord, which has been, Milord, accepted by the trial. So you are, Milord, here in my respectful submission, you can't take advantage of your offer something which is not binding upon you. So anybody and everybody, Milord, who will come up, file a suit against a fictitious person, get a degree, and then when I go to resist it, Milord, I will have to pay occupational charges. What is his right to accept? Me ask this question to myself, to accept rent from me on the teeth of a document where, Milord, the landlord is giving me the right until today I'm paying. So a person whose right has merged with the international club, surrendering its tenancy, is now seeking, Milord, an eviction against me on the basis of a degree passed against somebody else, not against me. Take it for instance, Milord, that he filed a suit against me.
Mihir is still alive.
I don't know. I am paying. I can show you a document.
Who is giving you the receipt?
Bank account. Every month it's going. And kindly see page 44. Kindly see page 44. I'll show you a lot.
44 of your opposition.
Stay up. Yes. Lord, first kindly have a look at 42. Have a look at 42 once. But this will be germane, Milord, even for the appeal. Kindly allows me to read it for your lordship. By the indenture of lease dated 24th February 1973, the premises number 42A Shakespeare Sharoni with holdings standing thereon were demised to the International Club by you on the rent and on the terms and conditions mentioned therein. Clause A, Milord, your lordship may, that name comes in Jenny Christensen, so allow me, Milord, to place that. Inter alia provides that the club shall have the right and liberty to sublet as residential quarter the first floor of the main building of the said club without obtaining your consent. Accordingly, the club did sublet the first floor of the main building to Jenny Christensen. Subletting, admitted here. So 16, Milord, is a right that he has. He had then. Recently, you requested us in writing to surrender the said first floor to you in consideration of a paying to the club such and such. The committee of the club at a meeting held decision recently accepted your offer, and in pursuance of the taken therein, we are herewith surrendering, admitted fact, surrendering the said first floor of the club's main building from our tenancy under the said deed of lease in your favor with effect from month of January 87. In other words, from January 87, you will pay rupees 1500 in consideration of our surrendering the said floor in your favor. Save as aforesaid, all other terms and conditions contained in the said deed of lease shall remain in full force and binding. By reason of aforesaid, you are at liberty to collect the monthly rent payable to us by Jenny Christensen in respect of the first floor. Accordingly, we have also written to Jenny Christensen to atone its tenancy in your favor with effect from 1st January 87. This is responded by Mihir Law at 44. He doesn't accept.
You say International was the tenant under Mihir Law. It was sublet to Jenny.
Yes.
Up to this, it is admitted by both parties.
Yes.
Jenny put you as a licensee.
Yes.
Thereafter, International surrendered in favor of the superior landlord, Mihir Law. The moment International surrenders, subtenant under International also gets extinguished. The subtenancy by virtue of that surrender. Therefore, it becomes open for being let out fresh.
Yes. And the possession was not with him. Actual physical possession was not with him. It was with me.
It's admitted that you were a licensed and
then also, Milord, at 44, your lordship will see how the landlord, Milord, is granting.
This is your letter.
This is Mihir Law's letter to me.
The letter which you rely on.
I'm relying.
Yes.
International Club, second
yes.
of the said premises in which Jenny Christensen was a subtenant. The first floor has been surrendered to me since 187. That the said Jenny Christensen service apartment without the written consent of the International Club had inducted you as a tenant. Marks it. That is a subtenant under the International Club. Thereafter, Jenny Christensen, after the surrender by International Club, claimed to be a direct tenant under me, not only in respect of the first floor of the premises, but making absurd and illegal demands that the tenancy included outhouses, garages. That's why that suit was filed. and claim the open courtyard facing Shakespeare Colony on the northern side of your flat as amenities annexed to the tenancy. Naturally, I cannot agree to the absurd demand of Jenny, which would entail parting with or handing over possession of valuable lands and structures to the said Jenny, without any consideration whatsoever. Accordingly, I cannot accept the rent sent to me by the said Jenny Christensen, which would result in heavy financial loss to me. As the income from rents is my sole means of sustenance, it is not possible for me to be deprived of the rents indefinitely and lead myself and my family members to acute financial distress because of the stringent demands of Jenny
Mr.
Christensen.
Chatterjee, give us half a minute.
The next line would have been a little important below if your lordship.
Yes, please the next slide. then.
Yes. I therefore accept you as a direct tenant.
Yes, yes, we've seen the intent.
the City Civil Court at Calcutta, whether Mir Kumar law or international, but made party.
No. No. কেন ওরা জাজমেন্ট দিতেও ছিল না, ডিগ্রি হোল্ডারও ছিল না।
Because they were, beloved, this is not an
Not even as a pro forma opposite party.
This is not an beloved, it is from the cross title of the plaint, beloved, the parties will be decided. I can't bring in, beloved, somebody else and ask his rights to be. Beloved, I will have to.
Have you got a copy of Astaram, Mr. Chatterjee?
Yes, have a look at Atmaram.
Yes.
Atmaram, beloved, subject to correction, beloved, your lordship kindly, beloved, doesn't take me amiss. Have a look at the last part, 718. Beloved, if I've just marked it a little.
Yes, it's no issue.
Whose book?
This Bar's book.
Don't.
Take two. It will be beneficial for somebody else, beloved, who looks into it.
Not if he's for the other side. Thank you.
Beloved,
ঠিক আছে, দুটো কপি আছে।
হ্যাঁ, দুটো কপি হলে ভালো তো।
Thank you. কোথায়?
এটা দিয়েছি তো বই।
আপনি বইটা নিন, আমার কপি। Thank you.
আমার একটা দাও না।
এই প্যারাগ্রাফ হচ্ছে 19
718 last part, that if he would have with effect from that day, the tenant is liable to pay mean profits or compensation for use of. I'm sorry.
আপনি যেটা বলছেন সেই লাইনেই কিন্তু জিজ্ঞেস করি। Mr. Chatterjee, the principle is that if you did not stand in the way, he would have got he has got a degree actually. He could have let out the property.
He could not have. That's my point.
He has got a degree.
Beloved, he's got a degree against some fictitious person. He
Wait,
could
but
not
that's
have-
your case. That has
It's
not
only
been established in
after
the
my
book.
eviction, he gets a possession, actual physical possession. And if he had actual physical possession, it's only then he would have been able to let out.
So that only if you succeed in this appeal, then only that
Beloved,
position will
even
come. As of today, he has a degree. He can get an eviction. He can enter there, and he can let it out.
It's an eviction against Jahil. He can throw Jahil out. He cannot throw anybody who is not claiming through Jahil out.
As of today, since you have lost your order 21,
Even if I've lost, it gives me 1 minute. If he gets a degree against Jahil,
whoever is there, he can evict. As of
no,
today,
who's claiming under Jahil, he can evict. He can't evict anybody else.
in an execution case, it cannot be reopened behind the decree.
I am not saying
he
so.
has an eviction degree.
Right. Because
Whoever
so
is
that
there
degree-
can be treated as an agent of Zahir.
I bow down. If Milord, I am claiming through Jahil or my rights are limited to Jahil, I would have understood.
All this would happen if you succeed in your appeal.
Milord, even if I don't succeed.
As of today, you don't have a case. I mean, you may have a case in the appeal, but you are a nobody in the property because you have not been recognized. Your independent right has not been recognized. Even if you are there, you could be evicted today and he could have let out. You are resisting his letting out the property which is being compensated.
Mr. Chatterjee,
Allow me to
subject to permission of.
Yes,
Justice,
sir, please.
So please come to paragraph 90.
My lord.
If you have got. To sum up, our conclusions are.
My lord.
Have you got it?
Yes, my lord.
While passing an order of stay under Rule 5 of Order 41 of the Code of Civil Procedure 1908, the appellate court does have jurisdiction to put the applicant. There is you here.
No.
Before us, you are the applicant.
Right.
On such reasonable terms as would, in its opinion, reasonably compensate the degree holder for loss occasioned by delay in execution of the degree by grant of stay order in the event of the appeal being dismissed and in so far as those being concerned.
Correct.
Such terms, needless to say, shall be reasonable.
My lord.
So Chatterjee, I'm asking a simple question. Why this concept of law? Why this proposition of law cannot be seen in a broader spectrum? Ultimately, this way or that way, a gentleman possessing a degree is being deprived of on account of your litigation, where it has been found that you are ultimately unsuccessful. So because of, in the event you would have become successful in the Order 21 Rule 97, the position would have been other. But since you have not succeeded and you have approached before us with an appeal, we consider this a statutory appeal because 103 is practically a deemed deal. So, sir, what right we have got, and why, rather, why will not extend our power as has been enunciated in the case of the Atmaram property?
May I answer your lordship? My lord, my respectful submission is what it was all this while. Atmaram is a situation where an admitted tenant is under a degree where, my lord, there is a degree of eviction against him. There is a degree of eviction against the tenant, and he was resisting that degree. The distinction is fine, but it's massive. Kindly now have a look at the second paragraph of the paragraph that your lordship read. Have a look at that. That paragraph qualifies the first paragraph. In case of premises governed by, my lord, kindly got it, Lord?
Yes, sir.
Governed by the provisions of the Delhi Rent Control Act in view of the definition of tenant contained in clause L of section 2 of the Act, the tenancy does not stand terminated merely by its termination under the general law. It terminates with the passing of the degree for eviction. Terminates for the degree of eviction. Then, with effect from that date, the tenant is liable to pay mean profits or compensation for use and occupation of the premises at the same rate at which the landlord would have been able to let out the premises and earn rent if the tenant would have vacated the premises. So what is happening here, my lord? There is a privity of contract between X and Y. X files a suit against Y and gets a degree. It's then, my lord, Atmaram comes in. And to answer your lordship's query, my lord, X files a suit against Y and wants to evict Z. He is not, my lord, I am not fighting a suit, my lord, where I am claiming a right under me. I am resisting my eviction from a premises where, my lord, I have a rightful, my lord, right of tenancy granted by the owner. The owner does not want to evict me.
Which you could not establish in the first place.
Which I could not establish, my lord, if I suppose I could
At
not
least
establish.
as on this day, you could not establish.
My lord, the degree is it binding upon me? May I ask this question to myself?
Supposing
may I
you
ask this
lodge
question?
this appeal, what will happen?
Well, I mean,
How the amount will
everything,
be
because
covered?
whatever he wants to do, he will do. But whether he has a right to take money from me, my lord, a subtenant who has no right on the property is being, my lord, is evicting me.
Tricky point. দুটো কম্পোনেন্ট আছে একটা হচ্ছে এর এন্টাইটেলমেন্ট আর একটা হচ্ছে কম্পেনসেশন independent right. So his entitlement is also in question, whether he's entitled to get anything from you at all. If he's not entitled, why should you compensate him?
Because
As you are arguing.
I am arguing that he is not entitled.
That is the
I am
point on
not
which we are.
resisting a degree against me, Miller. That's the main important distinction from Atmaram and my case. I am not resisting a
But the
degree.
effect is that he is deprived from the fruits
He
of
might,
it.
Miller, if today
That effect remains.
just because he gets a degree, he cannot get an eviction against me.
I'm telling you one thing. It is known to bar as well as to the judges that the law is a dynamic subject.
Certainly.
When Atmaram property judgment came into force, myself was in practice.
Your lordship was, yes.
Yes.
You knew
At that,
my lord
used to come to our table regularly. Yeah.
Before you were there.
My lord was in
Before
room
you came.
number 13. He used to come to room number
Before you
used to come to room number
be
2.
that as it may, Mr. Chatterjee, but what I'm on, at that time, what was the usual order?
2005, we were in profession.
You were in
profession.
2005.
So be that as it may, at what time, what you appellate court used to pay or used to pass order? Stay, go on paying the admitted rent of the contractual.
Then Atmaram
Then the Atmaram a new concept of law has evolved.
But one
to that
line
was
of
not known to-
Atmaram, Milord, nobody, it was Mr. Raichodri's argument throughout, which nobody considered, was that it had to be reasonable. A 5 rupees rent could not be termed into Milord 5 lakhs rupees. Atmaram said reasonable. That's a different aspect where there is an eviction against me. But here, Milord, I am saying he doesn't have a right to receive rent.
That we have understood.
Yes, I am on that.
No, his right flows
And
from
right
the
to let out also.
right flows from the decree which you are resisting.
Milord, I am saying
we have to make balance on that. We have to make balance on
that. No, I'm sorry, never.
There lies the nicety of the law.
The nicety of the law is, Milord, that if he could have let it out today after taking possession from me, I would have understood. He is not taking out possession. That nobody will file a suit against an occupier. Somebody, Milord, against a mother, a suit is filed. I get a degree, get a monetary thing from the appellate.
Do you say that after suppose you lose as of today, you don't have a right, independent right. Today, if he executes the decree, whoever is found in possession, he won't be evicted, even if you are there.
Milord, my respectful submission, I'm not bound by that.
Because you have lost your order to rule 100.
I'm not bound by that degree yet. Appeal is a continuation of process. That's a different.
Physically, whoever is there can be evicted, Mr. Chatterjee.
Anybody who is claiming
that is what happens in reality also.
That's exactly what
because you have failed in your right as of today.
That's exactly why, Milord.
Appeal fails. If the appeal fails, as of today, whatever stands, by virtue of that, you don't have an independent
Milord,
right.
if an appeal fails, Milord, the bailiff will come and say who is Jahil. The appeal will, or whether I am Jahil, I'm claiming under Jahil. The
bailiff will not decide that.
But
bailiff will throw out whoever is there.
Cannot decide that. Bailiff doesn't know.
Bailiffs have become, the richer than some advocates.
That is true.
So, because they don't distinguish between Jahil and.
Judgment of Atmaram property is based on equity.
It's
based on equity.
Between a landlord and a tenant.
It's based on equity.
Between a landlord.
Whether you are entitled to the equitable relief or not.
Not me, him. Today, Milord, I am resisting a degree not against me. I don't want to trouble again and again. There are a few. I will, maybe your lordships are contemplating that I put in money, Milord, in the court. Now, once, Milord, if I lose, who gets the money? May I ask this question to myself?
No, Mr. Chatterjee, this entirely depends on which component we rely on ultimately. The component of compensating which apparently is stronger. compensating the decree holder from enjoying the fruits of his decree, which is the premise of Order 41 Rule 5 also.
Needs to balance, my lord, at that point of time. Fruits of a degree.
His entitlement vis-a-vis you may not be a relevant factor in Order 41 Rule 5 because this is the condition for stay. Stay of what? A decree. That decree which he cannot enjoy today, the usufructs of which by letting it out to some other person.
Yes.
You cannot put in a spanner in the wheel by saying that no, he cannot, you cannot physically evict
I'm
me.
bringing
He can.
in another aspect. I'm bringing in an aspect where my rights are not yet, my lord, decided as of today.
Finally
As of
decided.
today. My lord,
That is what we are saying.
Continuation of
Well, unsuccessful appellant, sir.
my lord, even if I my lord, now
Appellant has to answer.
I
Right.
Unsuccessful.
Yes, you are absolutely right.
appellant register.
yes, register
Be
on my
more precise.
my lord, register not of a degree against me. Kindly appreciates that.
But you are resisting the decree which he is the decree holder.
Then, my lord, if a situation like
And
this will,
he is being restrained from executing his
if a
decree.
situation is allowed to happen like this, my lord, then what happens is X will have a privity of contract with Y, but he will not file a suit against Y. He will file a suit against Z.
But think of the reverse, Mr. Chatterjee. Then anybody and everybody will come up, lose an Order 21 Rule 97 to 101, and come up and get a stay and say they are
That's
not entitled
exactly
from
what
us.
I'm trying to, my lord, say that
Because you have
kindly
lost
see-
one court.
Kindly seize the prima
Maybe you have
facie
got a
case.
very good prima facie case in the
That's
appeal. We are not
exactly what,
sure
my
of
lord, if
that.
I have a prima facie
Even there.
case, to
Even
go to trial.
That's why you are
injunction-
granting stay in the first place.
Absolutely. Now, today, my lord, what happens is that if your lordship still there is a prima facie case, but your lordship is now trying to balance equities. Now, equities in favor of whom? May I ask this question to myself?
Why not the degree
And for
holder?
your yes, equity in favor of the degree holder.
Absolutely.
I am there trying to, my lord, put a spanner on the wheel that he is telling your lordship that I am in possession. He is telling your lordship. I am not saying. He has produced documents to show that I am in possession. And he has obtained a degree against somebody else and wants to execute it against me. Kindly, my lord, differentiates this.
Mr. Chatterjee, visualize a situation.
My lord.
X is the landlord.
My lord.
Y is the recorded tenant.
My lord.
Who parted with the possession to Y.
My lord.
Z.
My lord. Subtenant.
Z.
So that's a ground of eviction.
Subtenant. When X goes to file and suit for eviction, against whom it has to be filed?
Why?
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 Not Z.
Not Z.
Though he is admitting that he has
parted
with the possession with to the Z.
I so bow down to your lordship. I'm saying so. That is exactly what I'm saying. I'm so grateful your lordship gave that example. So Mihir Law has to file a suit against the international club whose rights have gone and he is claiming under international club. Marks it. This is the right. Miller, this is so grateful to your lordship, Miller, that a subtenant doesn't have a right. That's what my lord said. He is the subtenant, not me. He is Z.
At least as on this day, he has a better
Your
title
lordship
than
gave an example. I'm taking advantage of that.
He has a
He
bigger
is Z. I am not Z. He is Z. Kindly appreciates that. I am that Y. And against whom that X can have a claim against me, not Z. Today, Z is wanting to evict me.
ভাবছি অ্যাপিলটা ফিক্স করে শুনে দেবো।
My lord, any day your lordship pleases, any day. Tomorrow, I'm ready.
কেন বলছি এখানে সবই অ্যানেক্স করা।
না কেন 27 একটা শুধু সেটাও রিলাই করে নে না অপোজিশন দেবার কি আছে আমরা তো রিলাই করবো ওই ডকুমেন্ট
প্রবলেম
এই বেঞ্চ
কেন বলছি জানেন প্রবলেম হচ্ছে জাজমেন্টটা গন্ডগোল আছে
those documents will let I
and Millard,
those are the plaints and all.
Yes, let him relate.
And on the death certificate, which
This is not a part of Order 41 Rule 27. So there another Order 41 Rule 27 cannot come.
the death certificate of Mihir Law, who will pass away.
So our predicament is that this bench will last for till Monday.
Tomorrow, my lord, I'm ready. I'm ready tomorrow.
The doctor also has to be ready.
Always ready.
Sometime.
He knows everything by.
After all, practically we are going
Because
to
if
hear
we
out an
reserve
appeal.
judgment on this will have implications in the main appeal. Come prepared on the main appeal, Mr. Datta.
But
Not this side of the vacation.
still will not reopen it.
My lord keeps it part heard and here's your rates
No,
interest.
no part. No.
This bench, no.
Because of my
Justice Shane will be in more difficulty than me.
absolute difficulty.
But will
You know, sometimes I'm sitting with
dispose of
him.
my
So many
No, then we
judges.
have to dispose of your.
Every day, my lord, we find this so many judges do not come and your lordships are, my lord.
No, then we'll have to dispose of this application first.
No, I am ready. Your lordship, any day, my lord, you're pleased.
No, the application. Mr. Datta has difficulty before this.
My lord, appeal also. Appeal also, my lord.
Still, Mr. Datta has some difficulty before this side of the patient.
I can't stand.
Lord, I don't
On
say
the
that,
day of
I
reopening?
don't say Lord, don't take it as a difficult. It's not no more inclination to work on vacation is almost knocking at the door. That's the it's not that if your lordship insists, I cannot come.
No, why should you insist?
What I was saying is, my lord, since there is a stay, my lord, your lordship has admitted the appeal and stayed.
Then
my lord.
may I pray for this? Then your lordship may do this. My lord, your lordship on this directs that the appeal and the application both would be heard out, my lord, immediately after the vacation.
But then you go on enjoying without the.
No, but just 1 month. On the fixes a date on reopening. Just 1 month. Nothing's going to my lord, fall in a month. They've 86, my lord, they have been trying to do whatever they've done.
We will record that Mr. Chatterjee has given an assurance that he will not seek any adjournment.
Records it.
Yes.
Records it. Records it. Like the other matter yesterday, my lord, records it.
When should you keep it, Mr. Datta? Appeal. Along with the application.
Stay up any day after vacation.
Seventh of January. 7th of January, we reopen on
Second.
2nd.
I was actually expecting a judgment because the way the lordship is divided, my lord, I was also divided.
Yes, we are.
In
Divided.
your lordship's
Intra-judge division.
in your lordship's
Not
conscience,
inter-judge.
my lord, this
Intra.
is exactly why I did not exactly cite Atmaram. I cited the principle because I was also having some sort of issue, but
No,
what I could not understand is that if I have a decree,
Yes.
and then
Your argument is very strong.
his defense is tested and failed. So we come back to Order 41, Rule 5 situation.
There are two lines of distinction. Otherwise, we would be totally with you. Because your decree is being resisted by them, you are being deprived of the fruits of the decree. No doubt on that. Two lines of distinction. One is that in all these judgments, it was tenant landlord and entitlement was not in question. The second thing is, Mr. Datta, which is related actually. If it was a money suit, then the component, the money, that would be the factor, the decretal amount. They would have to secure it. Whoever gets it ultimately, they or them. But here it's not that. It's compensating somebody. That somebody is you. Where the question of entitlement comes in. I mean, whether you are entitled to get this amount from him, if it was Zahir taking out an appeal against the main decree, then there could not arise any question. But he's a third party, he's claiming a right.
Right, my lord. So therefore, my lord, whenever
And on equity, Mr. Datta, we are being very candid to you. We are going to, because we cannot preform an opinion, we have gone through the impugned order also, the impugned deemed decree. You must have gone through that also. This is all we have to say.
I know that, but
Not anything else, but I mean, manufactured document, the grounds of holding.
no, but thing is this, my lord, what a very strong point which had fallen for consideration also is that if he is claiming a right, title and interest in an Order 21, Rule 97 under a third party, my lord, then that third party's presence ought to have been there.
Maybe, but Mr. Datta.
Without that, my lord, he is establishing a right under Mihir.
Mr. Datta, your case, at least in the from the annexes, it's evident that he was a licensee under you. You have not resigned from that position. Now, you have not pleaded anywhere when that license, when he was evicted. No pleading as to when his possession ended. Jenny, he was admittedly a licensee under Jenny.
Milord,
Because otherwise, Mr. Datta,
Milord, there is one very factual aspect.
presumption of section 100, previous section 140, previous evidence act,
Yes.
116.
This will not fall for consideration, not will, because what my learned friend has not shown to you, or Milord, I could not, because order 41 rule 27 is pending. I had on the very first day indicated that there are two flats. Flat number 1, flat number 2.
But see your subject matter. But see your,
his letter at page 48 of my opposition says that I am in possession of flat number 1. And Zahil is in possession of flat number 2, is admitted by the landlord.
But Mr.
So
Datta, you get a degree in respect of the entire first floor.
No, I know, in respect of flat number 2. Kindly see the degree.
Let us see the degree. Yes.
Kindly will not see the degree.
That was which page again, please?
Degree ka degree. Opposition?
Yes. Your plaint is at? We want to see the schedule of the plaint.
But plaint is not annexed.
Plaint is not available at all.
Kindly come to 53.
53.
53 is the degree.
Yes. 53. Yes.
All the schedule, all that flat number 2. Now kindly compare with the page 48. 48. 49 or whatever. Flat number 2.
49 is police.
Yes.
No, no,
So,
we want
Mohan
to see their letter. That letter. Which
yes, that Mohan Singh's letter. He is saying, I am residing in flat number 1. What had happened, Milord, is this. After Zahil Singh had probably, Milord, left, Milord, that flat was empty.
But he was, according to his document,
Yes. At
in respect of, at 44A or 44, in respect of the first floor, entire first floor, which contains both 1 and 2.
That's the letter we could not prove. That's the letter he could not prove. And even this letter says, Milord, that the landlord is disputing my claim in respect of other areas. Tara.
Original Zahil suit.
And that is the reason, Milord, the two belief reports found, every time they visited flat number 2, it was under lock and key.
No, this, it consistently, it said in this letter at least that the first floor was surrendered and first.
Yes. So the first floor was.
Yes, they could not prove that is the finding of the.
Yes.
Till now.
So therefore, flat number 1, so far my learned friend also knows that there is a separate suit pending against him.
Actually, in that suit of the law, was it stated that they are a license in respect of 2, flat number 2?
Milord, it
Again,
says,
first floor. First floor.
See, kindly, Milord, see.
Page 60.
Page 60. Are occupying as licenses under.
First floor.
Yes. First floor.
Apartments situated first floor.
Yes. Because the suit is, Milord, for my right in respect of the garage.
And this is a suit on basis of garage.
I am on the question.
Yes, but in that suit, you are also relying on this. You are relying on this. Mihir Law himself is saying that licenses under, you are in respect of entire first floor, which you are saying also 1 and 2.
Yes.
And that they are licenses under you in respect of the entire first floor.
So therefore, if you add up with his here,
then you cannot distinguish between 2 and 1.
So therefore, flat number 2 was in, if flat number 1 is in possession of him, because a suit is pending against him in respect of flat number 1. He has to show, which he could not, that so far as flat number 2, how did he come in from Zahid? Where did Zahid go and where?
So, Doctor, as per your Mihir Law's, the plaint which you rely on at page 59 of your, this is your opposition? Yes. Opposition. Here, Mihir Law says in paragraph 2 and 4 that basically you were a subtenant Mihir Law, then international under that you, and they are a licensee under you in respect of the first floor of that premises, which contains both 1 and 2. Now you seek eviction in respect of 2. If this be true, then their license is in respect of the entire first floor, including 2. So let us focus on 2 for the time being. Let us forget 1. Then their license is in respect of 2 also. You get an eviction decree against Zahil, who is in 1. In the process, you are getting the entire.
No. I am getting a Zahil is in 2. He is in 1.
All right, even then, you say that, but
It's a joint license.
no, not that. He has been exclusively mentioned to be a licensee in the plaint of Mihir.
Yes.
Zahil is not mentioned. I don't know whether
Yes, Zahil is a party.
Zahil is a party, but how has Zahil been?
That's right. 1 and 2, different number 1 and 2.
Yes, but how has what is the occupation of Zahil here?
But it has licenses under here in respect of the first.
Pursuant to the plaintiff, 3 were them. Who was Zahil was 2.
1 was
1 and 2. Yes.
Mohan Singh. 2 was Zahil.
So paragraph 2 clearly says at all material time the
Yes.
defendant number 1 and 2 where are still the resident in the apartments situated in the first floor. So it's a plural number. In the main building of so
There's some
at least
vagueness.
more than one.
Some vagueness
is
is there.
And vagrant 48 below. I am an occupation in flat number 1. That is where he is coming below. My endeavor was only to show that the person against whom I have obtained a decree was there. And his attempt is to show that where did he come from superseding that man. And he has failed in proving that.
সোমবারের ভিতরে দিলেই তো এই স্টেটে অকুপেশন চার্জটি ডিসাইড করে দিই যেহেতু উনি পারবেন না ছুটি যাবে এটা ডিসাইড করে we'll keep this order reserved. We'll pass orders on this. Appeal will decide later.
And also C69A. The Lordship will see, my lord, the entire of the opposition, which my learned senior friend is relying upon. Have a look at paragraph 12 and 13. This is Jenny's, my lord, suit and Mihir's written statement. Sees paragraph 12 and 13. That's why I said, my lord, I'll rely upon their document.
Yes, all along first floor, there is a
Yes.
consistent strain of Mihir's
Yes.
apartments.
Yes.
Flats which
Both of them are. That is Mihir's statement, consistent statement.
that's inconsistent statement, but
On which you rely in your opposition.
He is relying.
I rely only, my lord, for the very simple reason.
You cannot pick and choose. If you
No,
rely, you have
I'm not, I'm only because the question was where did Zahil come from? He did not come
that is
from.
his question, not yours.
And I answer to that Zahil is there. If Zahil is there and I've got a decree against Zahil,
Zahil and he
I am also there.
have coextensive rights then, as
so
per
he
Mihir's
is not,
statement.
that is not his case before the
He's
trial.
saying so.
That is not his case before the trial court.
Mihir's plaint says that.
Right, my lord.
If that be so, then you have never explained when he left possession of that premises, when he vacated.
Who in the flat number 2? He's the
In entire first floor,
my lord, what his
including flat number 2. Yes, in flat number 2 also.
Yes, his case is that so far as flat number 2, he was resisting flat number 2. He was
Yes.
resisting flat number 2. He was not. He is saying
Which is on the first floor.
on the first floor. He is never his case before the trial.
So
court.
he's resisting flat number 2 because you have obtained a decree in respect of
Right,
2.
right.
He
So
does
his
not. He
case
never
is-
restricts his claim to 2.
No.
He says
There's a
first floor.
separate suit filed by them.
He says first floor. Your suit was decree was for 2. That's why he's resisting 2.
Right. And his case for resisting 2 is not that me and Zahil were both tenants of the first floor.
No,
1 and
he
2.
says that his possession as admitted by me regarding the first floor was never vacated. So you obtained a decree against a third party, and how can you expect to be compensated by him? You don't have any entitlement because you have never evicted him.
Because the thing is this, my lord, his case before the trial court, if your lordship will see, is not that he is saying that I along with Zahil was there or Zahil was, you could not have obtained a decree.
Maybe, but Mihir says so.
But his case before the trial court is that I am a tenant in respect of the entirety
also there-
under Toru.
Right.
Under-
There
under-
cannot be any difficulty regarding Xyle because Xyle is the judgment debtor. You can get an execution. The
Yes.
problem arises only in respect of this person. Now, this person, he has been admitted by Mihir to be a licensee under you in respect of the entire first floor.
Correct.
So he has been left out in your suit. You obtained a degree against Zahil only.
Very well.
Now he says, when was I dispossessed? Mihir admits that I am a license in respect of the entire first floor.
Going by that paragraph in the plaint where it says that
Consistent case of Mihir. See written
I'm
statement in
saying-
your suit.
I am relying on that only for the purpose to show that Xyle was there. King Willard,
Yes.
if your lordship reads 44 last line, which my learned friend was relying upon.
44 of the stay application. Yes, last line.
I therefore accept you as a direct tenant. He was disputing the right of
1 and 2.
1 and 2.
right. Thereafter, Mihir law on 21st July, page 45, gives flat number 2 separately to him. If these documents could not be proved,
No, but you admit him to be a licensee.
I admit him to be a licensee in respect of flat number 1, Xyle in respect of flat number 2. I filed a suit against Xyle because he was in flat number 2. And the fact remains that before the trial court, your lordship will find that he has not been able to prove his possession in respect of flat number 2.
Yes, there's a finding.
That he
There's a
could-
finding in your in the present impugned order.
Yes, that he could not prove his possession.
Rent receipt
Rent receipt is not possession. Rent receipt is something which has been doubted.
Bailiff has come and said, I'm in possession.
No, it's under lock and key. Anyway, that will be decided. So, Millard, I can visualize, but since the evidence I am not going into, I can visualize what has happened. But
Flat number 2 is what you have obtained a degree in respect of flat number 2. And then the page 46 grants tenancy in respect of.
that is what he could not prove, those tenancy documents.
Rent receipt is there.
That is a different proportion. He has lost
Rent
it.
receipt is there at 48,
Established.
49, 50, exhibit 3 series. Mihir law signs it.
Since at the order, heard learned counsel for both sides. Pushed up. Since arguments and counter arguments have been advanced at length with regard to the proposed fixation of occupation charges as a condition for the stay granted in favor of the appellant, we reserve judgment on the stay application. Pushed up. Very well. When we pass order on that, we'll pass directions on the paper books also. Informal paper books by you.
So grateful. So
we had considerable time to pass.
it was a pleasure hearing.
It was a pleasure hearing both of you, actually. I mean, on this point, I never imagined that we would be hearing for so long on this. We were one should never be overconfident. On Attaram, so, I mean, such extensive arguments and so good quality arguments.
So grateful to you. And my lord used to come to Bar Association room number 2. I thought was in
No,
13.
question was not regarding Zahid. Question is regarding you.
So grateful.
Whether you had knowledge. Because Justice Shen was temporarily against you. So you are nodding your head. And you are naive and we won't understand.
When my lord was district judge of Birbhum Miller, I went and argued before.
Don't add the even. You might have gone then.
So grateful.
Thank you. যেটা ঠিক হয়ে গেল যেটা কারেক্ট করে নেব দুবার পেয়ে গেল তাইলে আমার হয়ে গেল দেখি চিন্তা ভাবনা করে একটু দেখি কালকে সারাদিনটা আছে আজকেই চিন্তা করে নেব কল্পনা এখন তো টাইমও পাবো তো কিছু পারি না ইয়েস that was the understanding
He will be here, I should start.
yes defect
That was released. That was the defect. There is no
defective yes defective
Valuation statement has to be erroneous. Does not tally with the certified copy of. Memorandum of
60,100 you have stated the value
41,000 আছে নাকি না 4,100 কাটাকাটি চলেছে
4,100 তো
4,100
না প্লেনটি দেখছি
ডিগ্রি দেখছি তো 40,000 উপরে পরে
it should be same as suit valuation yes so 60,100 what did you get suit valuation was 4,100
Change, my lord.
we'll give you liberty to correct the the memorandum valuation statement correct for liberty we are recording and liberty and then hearing you now
Yes.
leave is granted we are granting that liberty we are leave is granted to the learned advocate on record for the appellant to carry out the necessary amendment to the valuation statement in the memorandum of appeal to bring the said statement in consonance with the value of the suit as reflected in the impugned degree. Carry out that correction during the course of the day.
Yes.
Even if you lose the matter.
Yes, my lord, of course.
Yes, Mr. Chaudhary.
Second appeal admission, my lord, percentage-wise chances are more, my lord, that it will get dismissed.
No,
in
no,
eviction.
no, no, not at all.
But this is, my lord, a case where I will try my best.
We forgot to bring copies of the premises tenancy agreement.
I have, my lord.
এই আগের দিন আপনাকে বলেছিল যে 97 একটা আনিয়ে রাখতে আমি বলেছিলাম পিএ কে
এই তোমার কখন আছে?
একটু কপি 19 premises tenancy act 1997 এক বলেনি না দেখে নিন তো আনাবার কথা কিন্তু ওয়েস্ট বেঙ্গল premises tenancy act 1997 এর কপি আনাবার জন্য বলেছিল
Sections which may be relevant.
Yes.
Is my lord 6(1)D, which is reasonable requirement, and 6(1)J, where my lord tenant has acquired or constructed house or flat elsewhere.
Just try
Now,
to.
these were the two, my lord. These are the two sections which are relevant.
Section 6 and section?
Section, my lord, reasonable requirement, section 6(1)D.
Yes.
And my lord, section 6(1)J.
If you can give one copy of the book.
Yes, yes, Lord, I just. Lord, I have soft copies, my lord.
To remove that, I cannot see
sure.
the honorable judge.
Yes.
Not,
yes.
So far J is concerned, is any issue has been framed by the trial court?
By the appeal court. And trial court has also decided. Now, my lord.
1J is concerned, it was not there, not an issue before the trial court.
Indirectly, yes. Indirectly, yes.
Yes.
Now, my lord,
9 issue number alternative suitable accommodation.
Yes, please move on.
On judicial perversity, 3 counts, non-consideration of material on record. Number 2 is, my lord, failing to appreciate, which is really a branch of, my lord, non-consideration of material on record, failing to appreciate material on record, and, my lord, coming to conclusions which are completely, my lord, if I may use the expression, not correct and absurd. And lastly, my lord, not dealing with the reasons given by the learned trial court for my lord, dismissing the suit. Not dealt with at
Mr.
all.
Chaudhary, the suit was filed on D and J.
Suit was filed on that and, my lord, other grounds also.
Defaulter,
Which, my lord,
offense, unauthorized occupation.
So dismissed on all the grounds, obviously.
all grounds and, my lord,
Appeal court
all
granted-
grounds,
appeal court granted it on D and J. All right.
Very good. So appeal court found that the plaintiff reasonably required the premises.
Yes.
Appeal court also come to a finding that you have an
That
alternative.
I have alternative accommodation. I have acquired alternative accommodation.
Let us see the relevant findings.
My lord, may I show your lordship the trial court judgment first? My lord, I'll be very brief. My lord, my lord, I won't read the whole judgment. I am going to take your lordships to a particular page and indicate what is dealt with. My lord, please start from page 101.
Give the internal page of the trial court, Mr. Chaudhary. We are on
Internal page is 18. This is from where reasonable requirement discussion starts. Findings from, my lord, page 104.
internal page.
I'm sorry, my lord, I'll use it in future. 221.
21. Yes.
First issue, my lord, from the middle of the page is what is a joint family? Because plaintiff had claimed on joint family. So, my lord, the learned judge, my lord, comes to a finding joint family means the person and all those dependent upon him. 18, my lord. 18, I'm sorry, 21 of 36.
Page 21.
Yes. So, my lord, joint family, so therefore family members means all those who are dependent. This is decided, my lord, at page 1.
Family members means all those who are dependent.
All those who are dependent, this is decided. He and all those who are dependent on him. Next. My lord, page 105.
Kindly place that portion, sir.
And I shall do that. My lord, in 104, my lord, second paragraph. In the present case, as mentioned above, plaintiffs have stated that plaintiffs have a big joint family consisting of plaintiff numbers 1 and 2, their 2 sons, father of the plaintiff number 2, his 5 brothers, 2 married sisters, along with uncles of plaintiff number 2, having their respective families. But due to insufficiency of accommodation, they cannot reside jointly together in the suit building, and the suit property is very much required to them for their own use and occupation. An absurd story.
Next.
While adjudicating this point, note should be taken of that presently in general as per law, a person's family is considered to be his or her domestic unit, including dependent parents, siblings, spouses, unmarried children. It has been mentioned that there will be several relatives, but legally all of them are not included in the term family or cannot be termed as family members.
Plaintiff number 1 and 2 are husband and wife.
Yes.
2 is the husband.
Yes.
Now they claim that their families, the spouses, their 2 sons.
2 sons.
Father of plaintiff number 2, that means the father of the husband.
Yes. Father of the husband and his brothers. He's got some 4 brothers.
Brother of the father.
Yes. No. Brother of the husband. Husband, wife, 2 sons, husband's father, and, my lord, husband's brothers.
And 2 married sisters.
And 2, my lord, married sisters.
Along with uncles.
Yes. Now, evidence.
Adduce any evidence?
Did
you adduce any counter evidence to show they live elsewhere?
Yes. He's admitted in cross-examination that they live elsewhere because of their work. And one by one, it all falls
Let us-
apart.
Let us see.
That's not considered, that's considered by trial court, not considered by appeal court. Whatever trial court has considered to give the judgment, appeal court has ignored. And I'll show you, Your Lordship. So, my lord, meaning of the term family has been considered in such and such. Furthermore, in such and such, it has been held that the expression own occupation means occupation of himself and of all other persons who are dependent upon him. Again, in such and such, it has been opined that family includes members of landlord's family and those persons who are dependent upon him and whose responsibilities landlord has accepted. The above mentioned decisions make it clear that as per the intention of legislature, requirement of landlord himself, of a member of his family, or of a person upon whom a landlord is dependent or who is dependent upon the landlord can be considered to be reasonable requirement of the landlord for his own use. In paragraph 6 of the plaint, it has been categorically averred by the plaintiffs that the father and uncles of the plaintiff are in joint mess, but for the purpose of their livelihood, they are living at their place of work.
PW1 in details gives us places.
Yes, in evidence. Contentions of plaintiff is corroborated by evidence of PW1.
The suit property is situated where?
Hathibagh. And while deposing on behalf of the plaintiff, he has deposed during his cross-examination as follows. One of my brothers, Dhirendranath Paul, resides with his family at Howrah. My another brother, Horendranath Paul, resides at Baguihati.
Give me a second.
Yes, my lord.
Whether the plaintiff number 2 is an advocate?
Yes.
Sir, I want to request.
Yeah, I also know him. It doesn't matter. I also know him and I know your lordship. No chance. We have no difficulty.
I have.
Also, may have difficulty after it is carried to Supreme Court. Say this is the only ground.
No, I would not allow.
No, you are nobody.
That is also true.
ঠিক করুন। Very good. We'll keep it on Monday. On
Monday.
Not on Monday. Tuesday.
Milord, but after Thursday, Milord, please don't.
If you can't take it up on Tuesday,
then after vacation.
Just Friday.
Next Friday, I'm parvo na.
Next Friday. No Friday, we cannot take it up on any Friday because we sit singly on Fridays.
যেদিন থাকবি না সেদিন রাখ।
Let us keep it on 17th.
Yes.
If you can't.
No, Milord, I'll be here on 17th. If I miss by
can't
any
reach it,
chance,
yes.
Milord.
No concession. Date has not been announced. No concession.
You have only created restrictions.
একটা order now.
Milord, I called him up to take permission. He said he relied on not overlap. He said there'll be overlapping. Whoever Milord wants to do anything has to register with me. I was the first to call up and register.
For what?
For Milord.
The treat.
Yes. First to register. Then he shows me some archaic law and says till Bar Council recognizes you, you cannot. So I withdrew. Now 5 people have beaten me to it and only he is responsible. So he's stopped from complaining.
Since one of us is not inclined to, since one of us within bracket, Sen J, is not inclined to take up the matter on personal ground, comma, let the same stand adjourned till December 17, 2024, comma, when the composition of this bench is scheduled to change. 17.
There are other grievances I shall tell your lordship on that.
It's the problem of people who don't understand jokes.
My lord, I have one request, my lord.
Yes.
My lord, that item number 29, I appear for the respondent. I just submit before your lordships that the party will give that's alimony, banker's check and all. Now, when I yesterday night, he told me, yes, I will pay. I'll take the check and go there ready and all those things. When I went out from this honorable court, Then I could not find him. Then I rang him. He told that where I will get money now. I am cannot give.
When have you kept it?
My lord.
When have you kept the matter? Next schedule?
Monday, my lord.
Monday we'll attach his salary. He'll
Yes,
get
my
the
lord.
money then.
I beg apology, my lord, because I have
No,
submitted.
you are not at fault.
As
You
per
remind
the
us this
instruction.
when you take up the matter on Monday.
Yes,
Will be the bench will be the same. You remind us when we will call the matter on Monday.
my lord, my lord, my lord.
And we will record your today's submission in the web.
Yes, yes, my
No,
lord.
make that submission again.
Yes, my lord. Yes, my lord. Yes, my
Because it may change in the meantime.
Yes, my lord.
It may impress upon him that this will happen on Monday.
Yes, my lord.
His salary will be attached.
Yes, my
He
lord.
gets what, 81,000 or something per month?
80,000 or no?
Yes,
81,000.
near about 1 lakh because upper division clerk or something like that.
All right. So we
My lord, this
declare
is
you hostile.
transfer brief. I don't know the client. My clerk has brought him.
This is the difficulty.
We declare you
Transfer.
hostile to the client. So we'll not hear you. I will hear the client.
My
Please
lord.
come back on Monday. We'll hear.
My lord. Deeply obliged.
কি বললো?